All persons on any duty for the Honorable, the Justice of the Appeals Court, now sitting in Boston, far within the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Please be seated. Good morning, Your Honor.
Good morning, and good morning to everyone. Welcome to the Appeals Court. In fact, this is our third case of the morning, as we've had two remote arguments already. It is number 23876, which is Commonwealth versus Shanley. It is a partially impounded case. I trust that the attorneys know what's impounded and won't refer to it. Our procedure is 15 minutes per side with no rebuttal. We've read your briefs with some care. In this case in particular, there are many, many issues, so it's possible we're going to keep asking you questions after the 15 minutes is up. If we ask one side, we'll give the other side as much time should they want it. And with that, we will hear from Attorney St. Lawrence.
Good morning, Your Honors. May it please the Court. Timothy St. Lawrence for Charles Shanley. I'll start with, if I may, with the multiple complaint issue, where we submit that it was improperly admitted at the trial. And I'll focus first on what I think was the most troublesome one, which was the nurse who examined KW at the hospital. She was allowed to testify at trial to the details of what KW told her during the examination.
Was there objection?
I'm sorry?
Was there objection?
There was not objection.
Was there an attempt to redact the medical records to take words like assault and assailant out of it, like in almost every other case I've ever seen?
That was talked about during the trial.
But not done, and no objection?
That were missed, absolutely, yes. But the testimony, this was live testimony of the witness, where she was allowed to repeat KW's accusations that a male at the Motel 6 had assaulted her, specifically had penetrated her vaginally and orally with his penis, and also vaginally with his tongue, that he did so by using force to hold body weight to hold her down. She's allowed to testify that KW told her this twice, at the beginning of the examination and then again later in the examination. My understanding is that these are documented obviously in medical forms, which are admitted in evidence, and during the trial they're put on some kind of overhead projector so the jury can follow along with the testimony. I understand that this kind of testimony is not hearsay, or there's an exception potentially to the hearsay rule, but that doesn't mean they're automatically admissible. They must still be relevant for a purpose other than corroborating the victim's story, and must be of sufficient importance to a fair understanding of the Commonwealth's case. And it's not here. It served no other purpose in our view than to just...
Is that the purpose of the Ramsey site that was in your 16L letter?
Right. I think Ramsey says this. I think a case you were involved in, Judge Cruz, talks about this. This is not new. This is... There's got to be a relevant purpose other than repeating the story, because we know that's prejudicial evidence, and that's why we have the first complaint rule. We only want one of those. So if we're going to have multiple, it has to be not only relevant to another purpose, but it has to be the probative value has to outweigh the prejudicial effect. So it has to really be.
Which is true. Which is true of all evidence. All evidence.
Of course.
We can't have it if the risk of unfair prejudice substantially outweighs the probative value. I mean, I'm stuck on substantial risk of miscarriage of justice. I mean, I don't know. I never know how to sort that out. And we're asked all day long to sort out what might have happened if a lawyer had made objection. And I don't know how to sort that out here exactly.
Can I
I'm
can
happy to hear if you have help.
So that was one piece of the piling on, but there were other pieces of the piling on. She reported it to Officer Garneau. There's medical records that she reported it to the EMS when she's transported to the hospital. Now, there's also no instruction about this evidence, especially about the live testimony.
Did you ask for such an instruction?
No, but I'm going to prejudice now. The substantial risk is that the jury now can use this. There's no limitation on it. It is referenced in the closing. And this is a close case, I would submit, right? This is a true credibility contest in that the defendant is testifying in this trial. There's no physical evidence in support of her story. So in a close case such as this, where the jury heard about 9 hours of evidence, they're deliberating for 12 hours, they come back in the middle saying, after careful consideration, we're not going to be able to reach a unanimous verdict in this case. So I would suggest this is a close case.
Were they given the...
Not at that point because it was the first return, but I just think it evidences that this was a close case and that the error, was material enough that we can't say that this was a fair trial.
Can I just ask, we've been saying substantial risk. You say substantial likelihood in your brief, and I understand that under Billingsley, we have 33E powers, at least if this was under 25B. But do 33E powers necessarily imply that we use a substantial likelihood instead of substantial risk, or is that only in first-degree murder cases?
My reading of Billingsley would be that if you determine this was a capital case that deserved 33E review, then you would be doing substantial likelihood of a miscarriage of justice, which is a more favorable standard to a defendant. I think you have to be, in that case, substantially confident that if the error was not made, the verdict still would have been the same.
Will Billingsley tell us that explicitly, or is that a gloss on Billingsley?
No, I think that they, in giving guidance to the appeals court, that is in there, that 33E review is under substantial likelihood. And because they're saying we're not going to look at this, other than giving it the appeals court jurisdiction, we're not really changing the powers under it, one versus the other, when you're undertaking that kind of review. Unless there's anything else on the multiple complaint, I can move on to, I would like to talk about the consciousness of guilt instruction. This was a contested piece of evidence at trial. Whether Mr. Shanley made this statement at the police station. A detective who was booking him testified that he made a statement after being informed earlier that the incident for which he was charged with took place at the Motel 6, that some minutes after that, later on, he says, I wasn't even at the Motel 6. And obviously he was. There was records of that. And so...
You say that the instruction needed to say they needed to find beyond reasonable doubt that the statement was made before they could consider it.
That's...
And I see that you had a cite in your 16L letter to a case named Robles, which approves an instruction and cites a case named Tony in which that's not an issue at all.
Right.
Tony doesn't support that.
Right.
So there's clearly a little bit of confusion about this in the case law, but isn't the sort of the more settled view that it's just, you know, a preponderance standard for whether the statement was made?
It does seem, I will say, it does seem that that's the understanding kind of in the community. But there is a case, you know, that we cite. It's an older
1890s.
case, of
Yes,
course.
it is.
But defendants, you know, derive significant
With no
rights.
cases cited in it.
With, you know, significant rights from the common law. And, you know, Justice Holmes was on that case, but it is cited, though, for different propositions of law up into present day. I mean, it's a venerable case, not on this point necessarily.
So for consciousness of guilt, there not only needs to, we not only need to have some corroboration, because you can't convict just based on a, am I getting mixed up here?
No, you're right, that it can't just be the consciousness of guilt evidence, that they are instructed on that you need more to convict.
Okay, so not only do you need more to convict, but you also need to find that the false statement occurred beyond a reasonable doubt?
I think where it's
So
a
there's
contested...
a double layer of protection there?
I think so. I think where it's a contested statement, especially, you know, here at a police station, which, you know, we want things recorded. I guess this was wired for recording, but didn't pick up this statement. That it does make sense for that foundational fact, because you are allowing the jury to, if they want to, really reach a conclusion of guilt, that he made the statement to distance himself, and this is what the Commonwealth argues, because he knew he was guilty, distanced himself from the crime, that he ought to have that protection that is derived from the common law, that, especially in a contested statement case, you know, we do this for humane practice, so it's not out of the ordinary, you know, to have a jury determine that a statement is made first before they can consider it as evidence of guilt. So we, again, because this was a contested piece, the prosecutor led off in her closing argument talking about this piece of evidence. This is kind of what pushes us over the top. This is why you can believe, because look at him. He's guilty. He knows he's guilty. That in a closed case like this, if they were properly instructed that they had to find it beyond a reasonable doubt, you know, it could have made a difference. And I say that because it's not recorded. There was another officer there who didn't testify about the statement. The statement was not documented in a police report after, although there were opportunities to document it, it wasn't. It first comes out at the grand jury.
Do we have the grand jury minutes?
No, I did not. You do not currently have them, but if you're doing a 33E, I could check as to whether...
Well, I mean, What's impounded in this case?
The victim's name.
I see, but nothing. It's not about the grand jury minutes.
No, but the grand jury minutes, and I'll leave that to the court, are technically, I don't think, part of...
Okay, but you say in your brief, I'm changing the subject
Right.
slightly. You say in your brief that the victim said something, maybe I can, it's in a public brief, I guess. So you say that she said that she had exchanged sex for money, no citation, no way for me to know if you're telling the truth or got it right.
Oh, I
The
see.
Commonwealth says she said she exchanged sex for drugs. No citation, no explanation. I don't know if they're telling the truth.
Okay.
What am I supposed to do?
So that came about as part of a proffer during the pretrial hearing.
So
which
in the pretrial hearing, there's a proffer that I can read that says what she would have said, and it's one or the other of these two things.
Right, and I don't know if it was or, like the question was, have you ever? I
Have
don't
you ever
know
done
that.
either, in which case we don't know.
It was one or the other that she admitted that on, I believe, on 2 previous occasions, she exchanged, and I haven't reviewed those in a long time.
We have them, we can
My
look at
sense
that.
was that it was drugs, was that it was sex for drugs. That's my recollection of it.
Because you're the one who wrote for money in the brief, so.
Okay, so that must have been part, what I mean is, that might have been proffered in the, I can't.
I mean, to me, that could be relevant, since our question is, does she, or your question is, should the jury know of engagement in similar behavior, and those aren't exactly the same thing. Your time runs short, although, as I said, this may go longer. I have a couple of questions for you. I don't understand your insufficient evidence argument about 25B, no citation, but you say he was sentenced on the same day. Why does that make any difference if it's 2 convictions for 2 different events, each of which carries a 3-year sentence? Why do I care what day he was sentenced?
Okay. In the statute 25B, it explicitly requires that the second offense occur after the first conviction. So where they were convicted of these 2 on the same day, the second offense could not have occurred after the first conviction. The offenses occurred within months.
Well, that I don't care about, but if you're saying the conviction has to come in between, then that I understand, although that's not exactly what you say. You say sentenced on the same day. Like, I mean, I understand they were also convicted on the same day, because I looked, or at least I looked at what was introduced at the short, enhancement trial.
Right. And I was short on words, and I should have done a better job explaining that. But that's our theory, is that this doesn't qualify under that 25B portion, because they're not, I think the word they use kind of in some of the cases is sequential, where the second offense has to occur after the first conviction, and that the proof is not there on that.
Okay, if it's conviction, but of course we can look at the.
Right.
Do you have any understanding about how these changes in the minibus came about?
I don't. There's no court record of what was going on there. So I don't know what happened, other than speculation on my part of how this all came about.
If this is under 25A, then what would be the parole date?
The judge is supposed to set a parole date of between 15 and 25, but that never happened as far as I know. So the parole date would be between there. I don't know how they would resolve it at the DOC, because there's not I imagine they'd go to the lower number, but,
Do you think we need evidence about, does there need to be an evidentiary hearing about this, or does the judge need to say more?
No, because it's plain what the Commonwealth was proving in our reply brief in court. We know that he was sentenced to life without parole. That's what the Commonwealth asked for. That's only eligible under 25B. Now, there's a case called Boyd when you picked one.
I'm a little surprised that you're resisting the Commonwealth's argument that your client was acquitted of 25B.
I don't think they.
Wouldn't that be better for you, because that has parole rather than no possibility of parole?
Here's why it matters to the defendant, because under Boyd, once they decided 25B, 25A was effectively dismissed, and it can't be revived on any remand. So they're both out. And we also argue that the subsequent on any remand should be out, because they didn't follow Richardson, which had come out by this point. They were supposed to pick between one of these sentencing enhancements. They shouldn't have gone under the habitual and the
But aren't you
subsequent-
both in agreement that the sentencing has to go back, the enhancements, because there's no jury waiver? I thought both of you
That
agreed
would
on
be
that.
our bottom position. We're asking for
We
more than
can't
that.
do any of the, if that's true, if there was no valid jury waiver, then there's nothing to talk about these, I mean, there might be things to talk about, but, it would get rid of, if there's both, it gets rid of both. If there's one, it gets rid of that,
Right,
right?
but
Right, so the fact that they didn't say which one may not matter at all, if we can figure out.
I do think it matters because Jeopardy did attach even though he didn't sign that waiver.
Okay, although the
So
question.
there are problems now on a remand of what he can actually, and it's not as if in our view, it comes down to they should have done it under Richardson at the time. They didn't. And so if you agree with us that the habitual stuff has to go, should they, who should the benefit of them having this subsequent still, which may have been dismissed had they followed the law originally? They were supposed to dismiss either the habitual or the subsequent. Should that benefit inure to them where they can try it again? Or, as Boyd says, we're looking to protect defendants by making the Commonwealth choose between one or the other, and it won't be available on remand had they done so.
But, where there's the failure to sign the jury waiver is essentially a trial error, right? You're saying new trial. Why would we say new trial but keep the Commonwealth locked into some decisions that they made after trial about what sentence to seek? Why don't we just send it back and say everything that was open at the beginning of the sentence enhancement trial is open again?
Well, if there's an acquittal, you can't.
Right. I guess my point is Jeopardy terminated on certain things by the way the procedure went.
But it's not a Jeopardy like insufficient evidence. We don't have a new trial on those.
Oh, I see.
Why is this?
Well, it is because, if there's insufficient evidence on a subsequent, you can't, and say that there was the same situation where there wasn't a jury waiver.
I understand the insufficient evidence
Right.
on the
Okay.
25B
Okay.
of the sequence, but why would we say?
I don't think it,
Is
a
that
due
the only
process-
reason it can't go back on 25B? And you say, why can't it go back on 25A if that went out merely because the judge arguably chose 25B?
So our
Why isn't
position,
25A still open?
the 25A is not open, we would suggest, because Jeopardy terminated on it once they chose. So the due process violation doesn't forgive.
So they screwed up with by going for 25B with insufficient evidence.
Right.
And they inadvertently dismissed 25A. So now you're saying that, can he still be sentenced as a second offender under the rape statute?
Well, as I just said, we think that would be unfair as well, and against Boyd.
Unfair or illegal?
It would be illegal.
And you can't apply both sentence enhancement statutes at once, is your position. But under your view, we can't, can't apply 25. So why can't the second offender enhancement for the rape be applied?
It's novel because I've never seen this fact pattern, but the reason is because if the Commonwealth had followed Richardson the way it was supposed to, and chosen, they would have had to choose between the habitual and the subsequent. And if they had done that, there's a there's a possibility, a strong enough possibility that they would have gotten rid of the subsequent, that Jeopardy would have terminated. And if they had done that, obviously there wouldn't be anything left in that case. So they shouldn't be rewarded, essentially. And I'm sorry, it is convoluted and a little bit.
Oh, no, it's convoluted.
I would just say, next time you have a case like this, don't hesitate to ask for a few more words in your brief.
Okay, fair enough. Thank you.
Well, hesitate. But Thank you very much. We will hear now from the Commonwealth. We went 8 minutes over, and if you want to go 8 minutes over, we're going to let you.
I will endeavor not to, but I appreciate it.
I'm going to ask you a question before you say, oh, okay, you can start. Then I'll ask you a question.
May it please the Court, Assistant District Attorney Krista Elliott from Middlesex on behalf of the Commonwealth. And, Your Honor, if you had a question.
Here's the question. You say the defendant was acquitted of 25B.
Yes.
Okay.
That he was not sentenced under 25B. I apologize if I misspoke in my brief.
I don't know what that means. That he was acquitted of it or convicted of it?
So I think that Section 25 is a sentence enhancement, so these are not standalone crimes. They
Didn't
are,
ask if they were, but you're convicted or acquitted of them, right? Judgments of acquittal enter sometimes in these cases.
yes, and they're-
Richardson refers to entering a judgment, or at least the equivalent of entering a judgment of acquittal on one of the two when they're sentenced to both, or convicted of both, right? Richardson, I mean, it's different enhancements, but that's what it says, right?
yes, that is what it says.
Because I'm asking this. So therefore, your position is, I don't want to put words in your mouth. Is it your position that he cannot be retried on 25B because he was acquitted of it?
No. And I think that I just would like to back up, because I agree that there is a little bit of, perhaps there were a couple of misstatements made on the record at trial around this. The defendant was charged in the indictments under Section 25. There was not an election in the indictments as to whether it was subsection A or subsection B. At the sentencing, trial counsel for the Commonwealth does not specify whether they are pursuing 25A versus 25B. However, what the Commonwealth says at sentencing is that, Your Honor, is that the defendant is now presumed to be serving the maximum penalty of the underlying crime, which would be a life penalty. So at this time, the Commonwealth is asking that the defendant be sentenced to life. The Commonwealth does not say life with or without parole.
But the judge says, and that's without parole, right? And the Commonwealth says, that's correct, Your Honor, or some phrase like that.
Yes, and I think that those were misstatements on the record.
Okay, so you think he was acquitted of 25B, which is something I would think would be good news for him. But how can you retry him on 25B if he was acquitted? So doesn't this go back for a trial on 25A? He has reasons why not.
Yes.
But leaving those reasons aside, are you going to pursue 25B on remand? You say we have to remand because there was no jury waiver.
Correct.
Are you going to pursue 25B despite this acquittal, or you're not?
I do not know the answer to what our trial strategy will be bring this back, but
I'm asking what the law requires.
Yes. I think that the law requires that the entire proceeding is void because there was no jury waiver.
If someone is acquitted at a jury trial of a regular crime, never mind an enhancement, and they didn't waive the jury trial, but jeopardy attached and the judge entered a judgment of acquittal, I have no doubt you cannot retry them on that.
Correct.
So why is this different?
Because when we have cases coming out of the Supreme Court, we have Monge v. California that talks about where a similar failure of proof, like the one that you were talking about, occurs in a sentencing proceeding. The analogy, the due process, or double jeopardy, analogy is inapt. The pronouncement.
I'm not really interested in what the U.S. Supreme Court says about some other state sentencing enhancements.
So
I'm interested in Massachusetts, where because a jury is required to hear this. So this isn't like the judge decided, wow, I think this was, kind of a heinous robbery. I'm going to give you, right? It's not that kind of enhancement. It's a kind that requires a jury to hear it.
Yes.
So it's something bigger than a mere enhancement, even though I understand that it appears under Richardson not to trigger double jeopardy. That's, I think. But I'm still trying to figure out why something that's a judgment of acquittal doesn't bar retrial.
My best case from Massachusetts is Bynum, which is a 1999 case, 429 Mass. 705 at 708 to 709. It stands for the proposition that a sentence enhancement statute does not identify a crime that has a freestanding life of its own. It concerns solely the sentence of a person convicted in violation of the underlying crime, which has previously been convicted of at least one other qualifying offense. The prior offense is not an element of the crime for which the defendant is charged, but concerns the punishment to be imposed if he is convicted of the underlying charge and the prior offense is proved. So which is pulling it, and just as it is in Mons, which I understand, Your Honor, that is the U.S. Supreme Court, not a Massachusetts court, but that is pulling it into that same genre as we are seeing coming out of the Supreme Court.
I just don't know the answer to that, because we do have Richardson, and it does talk about acquittal. And it seems to me that if you're acquitted of something, you can't be retried on it. It doesn't say, you know, the finding is nullified or something. It says acquittal.
So I think that one of the other things here is that I recognize the challenge that Your Honor is putting forth. And here we have this unusual situation where there is not a pronouncement at sentencing as to whether or not the Commonwealth was proceeding under A versus B, and the court does not specifically say we are proceeding under A versus B. So I don't know that we have an acquittal on B in that classic sense. We have a finding, ultimately, according to the MITs, that this is under subsection A, which is frankly what the Commonwealth proved. We did not prove B.
There was insufficient proof for B.
Correct. There was insufficient proof for B.
You can
Do you
see that
agree
there's
that-
insufficient.
Yes.
All right, so if there's insufficient proof, you can't retry him either.
Again, I think that the question is whether or not that same, that applies where we had no valid jury waiver. I think that that's.
How can it be that you can get more on remand from an illegal trial than you could have gotten this time? This isn't to give you an extra chance to dig up some evidence.
Of course.
Right? This is a retrial to protect the rights of the defendant.
Of course.
Right? So if you had insufficient evidence, don't we say there was insufficient evidence to convict of this, the end?
Frankly, Your Honor, I believe that likely what is going to happen is this is going to go back under subsection A. I just don't think that we have the same level of acquittal when we're talking about a subsequent offense statute that we would when we're talking about the actual elements of the crime. And that is the piece that I think is, I don't know of any case law that really clarifies this particular proposition. And I think that that's the problem we're all struggling with here, is that this is a very unusual situation, and we have this case law that talks about the differences between the principal offense and then the subsequent sentencing enhancement, and they do appear to be in some sort of conflict. I do not think that, based on the case
If there was insufficient evidence of 25B, we don't do 33E review, do we?
And here, I don't think this court needs to reach 33E review as it is, because
We're
the case needs to be
remanding
sent
for a
back.
new trial
The case
on
needs to be sent back. I would also note that, to the panel's question of my brother, out of an abundance of caution, because I was trying to figure out personally what was happening here, my office did reach out in February to the records department at the facility where the defendant is currently housed, and he does in fact have a parole eligibility date in 2028 right now. So we know he is under.
Based on what? The minimus?
I would assume so. I say that for the purpose of showing that this was under A. Any MIT from 2016 on shows that he was sentenced under
Okay,
A.
but if you could just go into court and say to the judge, they've mistakenly set a parole date for him, we did 25B, then that's, right, I mean,
Well, I think
ordinarily you'd like an order from a judge saying what's, yeah.
Of course, and Your Honor, I would note that if you look to Record Appendix 10, there is this notation contemporaneously with the actual sentencing enhancement trial that further orders of the court, offense 3 is a habitual criminal pursuant to Chapter 279, 25A. And I recognize that that's on offense 3, not offense 1 and 2, but that does highlight the fact that the court clearly at that time was sentencing pursuant to A. And it wouldn't make sense, frankly, for there to be some of these crimes being sentenced pursuant to subsection B.
I mean, except for where the judge says it's without parole and the prosecutor agrees and then nothing else is said about it, which
Yes.
looks a lot like life without parole.
And I think that those were misstatements.
right.
And I don't have any explanation for them outside of that. But it is clear from the assessment of the record that we had evidence sufficient for 25A, not evidence sufficient for 25B. There are no further questions on that topic. I will, and there may be more, and that's fine. But I will turn to the consciousness of guilt instruction. Contrary to my brother's argument, there is no requirement that the jury be instructed that they must find the defendant made the statement
You agree there's some cases that say so?
that treat those instructions with, say that this was an okay instruction, you mean? You're talking about the Robles case?
Okay.
So it does have to be shown beyond a reasonable doubt. You're just saying you don't have to say those
No,
words to
no.
the jury.
No, I'm saying so Robles was treated with a positive gloss, but so was in Commonwealth v. LaValle, that's 410 Mass. 641 and Note 13, a 1991 case. The SJC also gave its seal of approval to an instruction that said, if you find that the defendant has made false statements as to material facts, such statements may be considered as showing of consciousness of guilt without any sort of requirement of beyond a reasonable doubt standard. And here, what I think is happening is that my brother is conflating the consciousness of guilt instruction with the humane practice instruction applicable to confessions or admissions. And even in that humane practice context, there has to be a substantial issue around voluntariness in order for that instruction to come in. Here we have a situation where defense counsel did not want a contemporaneous instruction for consciousness of guilt, and in fact also did not want a consciousness of guilt instruction in the final charge. It was the Commonwealth that requested it and the court that agreed that it needed to be given. And the defense counsel, trial counsel in this case, also explicitly said that voluntariness was not an issue, and that's at transcript 3, page 25. The court also found at transcript 3, pages 24 to 25, that there was no Miranda issue, no alcohol, drugs, or impairment. So even if we were looking at humane practice, we don't have the voluntariness problem that you would.
So what's the standard of proof for this question?
So there has not been an explicit articulation. The closest I was able to find is in Commonwealth v. Roa, which is an unpublished panel decision from 2017, and that's at 91 Mass Appellate Courts 1102 at page 2. And again, it is unpublished, so I recognize that it is not binding on this court. But that case held that there was sufficient evidence for a judge to find by a preponderance of the evidence that, among other things, the defendant appeared, quote, extremely nervous and, quote, lied about the location from which he'd come. Then they would go on to say the nervousness and false statements were probative of his consciousness of guilt. So it's not an explicit requirement that is preponderance of the evidence, but it is an implication.
Which facts at a trial, at a criminal trial, have to be proven beyond a reasonable doubt?
Which facts?
Yes, this is a fact. He said it or he didn't say it. Which facts have to be proven beyond a reasonable doubt, and which ones can be proven by something less, I guess preponderance?
So most facts, we're looking at a preponderance standard. It is whether or not the Commonwealth has proven the crime beyond a reasonable doubt, with the exception of these voluntariness problems that we run into with the humane practice instruction.
So the crime is the defendant shot Bill. Mm-hmm. And the fact, did he shoot him? The jury can find that by a preponderance of the evidence. And now that's the fact they found. And now when it's time to figure out if it's beyond a reasonable doubt, they're taking that fact. Well, if he shot him, of course he's guilty beyond a reasonable doubt. And that's good enough?
So I think that there is a difference between an assessment of an individual piece of information that is coming before the jury and the overall summation of that information that's coming in. And we don't generally instruct the jury on what they have to find in terms of any statement that's coming in.
I've never seen a criminal jury instruction that has the phrase preponderance of the evidence anywhere in it.
I would agree with you.
And I would think a court might well strike one down if someone threw in, oh, but these subsidiary facts you can find by a preponderance of the evidence.
Yes, I agree with you. And I think that is why actually my next point in my outline is that although it does appear that there has been some treatment that this would be coming in based on preponderance of the evidence, that is not a requirement of the instruction. And we look to Tony for that particular proposition, where Tony essentially says that a judge should instruct the jury, one, that they are not to convict a defendant on the basis of the evidence of the false statement made to the police alone, and two, that they may but need not consider such evidence as one of the factors tending to prove the guilt of the defendant. There is nothing about this sentence or this being required to be proven beyond a reasonable doubt, or the jury finding that the defendant made the statement beyond a reasonable doubt. And that case has stood since 1982, and that it continues to be the controlling case in this area. There just simply isn't a requirement for it, for beyond a reasonable doubt.
Can I ask about the multiple complaint issue? So how is it we know that the first complaint was made to the victim's friend, whose name I won't use. But then, later that night, the victim goes driving around, and the victim says, "We talked, she tried to comfort me," and she was asked about her demeanor or feeling, and her demeanor was that something had been taken out of me, I felt like a zombie. The witness said they talked for 20 minutes, the victim was crying, very, very upset, wouldn't let the witness hug her. How does that operate as anything other than an assertion that the victim told the witness that it had happened again? I mean, what other issue, what is it relevant to?
Well, it's relevant to where we have a credibility contest here. It's relevant to the victim's demeanor. This is the first.
Okay, but credibility about the credibility of her initial allegation. The credibility
Yes.
of the complaint, well, her first complaint is admitted on the credibility of her trial testimony.
Correct.
So this further increases the credibility of her trial testimony?
Yes, because this is a witness who had known the victim for many, many years. I believe she also testified that she had never seen the victim so upset. And
Okay, so
Doesn't
doesn't that
every, oh, you ask it, same question, go ahead.
Isn't that implicitly, she was up, I mean, it says everything, but she told me again what happened. She told me again that she was raped and that, you know, she was very upset, et cetera. Why isn't that implicitly just a repetition of the complaint?
well, respectfully, I don't think that there's any indication in the testimony that about anything that was actually said in that vehicle. You know, the fact that
Right, but what other purpose does it serve unless that was the subject? I mean, if she was upset about losing her job or something that had no relationship to the charges, I don't know how it would be relevant, but it wouldn't be particularly prejudicial. But here, doesn't it just operate as further corroboration that the victim was telling the truth about the allegation? And isn't that prohibited by the first complaint doctrine?
I don't think that it is in this way. This testimony was incredibly limited and was merely.
But there was a lot of things that qualified. I mean, she told Officer Garneau, you know, the business in the medical records, the EMTs, as well as the physician.
She reported it to another officer as well, I think she said, right?
So I believe that there is the statement that the victim, quote, reported it to the police, and that was to Officer Garneau. And at that point, the parties went to sidebar. The Commonwealth said, that's not what I'm trying to elicit, not trying to get in anything. And
There's another officer's name, maybe it's the one at the hospital.
So at the hospital, the victim testifies that that officers came to visit her, that yes, she spoke with them. There's nothing about the content of that conversation. The officer also says, yes, I was there. And then he does not say anything about any conversation that the two had, and then goes on to testify that he
Went to the motel and arrested the...
Correct, yes. But he does not testify to any statements that were made by the victim. He testifies to his personal conduct and
She
his
doesn't
movements.
say she reported it to him?
No.
All right,
No,
I'll
she
have
does
to look
not.
at that.
And I may not have the exact site, and I apologize for that right here in front of me.
But she
no.
did say, I mean, not only did she say she reported it to police, and then there was the sidebar, but then she says she didn't originally intend to tell the police, but then she saw Officer Garneau, and she changed her mind, and she talked to him. Isn't that a statement that she told him?
So I do agree that this is where we get the closest to a problematic piece of evidence here. However, even if this is problematic testimony, there is no prejudice to the defendant, where his entire defense is that she was furious with me for not paying her, and therefore she went and reported this to people. That is his defense. And so the fact that there was a
You don't get to bring in multiple complaint testimony because the defense
I
is...
agree with you.
Right,
That's why I'm moving to prejudice. I'm not suggesting that multiple complaint testimony is appropriate. I'm suggesting that where that was the defense at trial, there can't be prejudice based on this limited statement. The statement was...
Well, but he's saying she's lying. And the point of these multiple complaints, and especially of police action afterwards and what the nurse wrote and so on, is that other people believed her. It goes directly to the defense. Lying people, we pretend, people don't believe them. We pretend, right? I mean, I don't know what people do. You report something to the police, I hope that they act on your report or investigate or whatever, right? But isn't that the problem with multiple complaint testimony?
So the problem with multiple complaint testimony is certainly that it can lend that an inappropriate amount of credence to a complainant. And of course, we allow the first complainant to buttress against the more problematic negative perceptions that can inure to a victim who is bringing forth a sexual assault complaint. And of course, that is true. But I think when we're talking about what is actually subsequent complaint testimony, the subsequent complaint testimony are those direct statements of what happened, or that something specifically happened and that you specifically told someone that you had been sexually assaulted, that you had been raped. And here, the vast majority of this complaintive testimony is not that. It is proper demeanor evidence. It is evidence to the state of police knowledge to kind of provide the police with an explanation for how they are moving from point A to point B. And the prosecutor—
Why is any of that? That I didn't understand either. What do I care that he went to the motel and arrested him? Why do I care that he arrested him? You say, I mean,
well, because
why are we telling the jury anything about that? The question is, did he commit the crime? The fact that he was arrested certainly suggests that the police thought so, which is a reason not to let it in.
I mean, frankly, the fact that somebody is appearing before a court to be tried also, but you can argue that makes
I agree, but it's hard.
Right, exactly.
It's hard not to let them know that's what's going on, right?
But it's similar, right? I mean,
well, you can't. I'm sure there are cases about, can you say that they arrested? Maybe there are some that say, well, look, they must figure he was arrested because he's being tried, but they don't say it's not an error.
Well, and
State
so
of police knowledge really doesn't seem relevant here.
So I think that it is relevant here insofar as there is additional testimony about, and it was the testimony related to the consciousness of guilt instruction.
Okay. So they can say while he was being booked,
yes.
You don't have to say what was the whole process that led up to him being arrested.
Well, but the process that led up to him being arrested involved the testimony that was limited to going to the Motel 6, doing some investigation, collecting information, and collecting the bedding. And so we need him to get to that Motel 6 to collect the bedding in order to explain why the bedding then goes to the crime lab to be tested. His testimony is not particularly extensive at that point about his investigation. You looked like you had a question.
Well, no, I didn't want to interrupt you, but we've been focusing on what may or may not be inferred from what was said or not said to the police. But we have also, as Justice Sachs referred to, we have EMT records, we have hospital records, and we have the SANE nurse's testimony. Is your position, and I believe you dealt with addressed the EMT in the medical records in a footnote, is your position that they're not complaint evidence? Because we understand what the statute is for admitting hospital records, but that doesn't alleviate the judge from doing the similar balancing, whether it's unfairly prejudicial. And here, based on the cumulative reports, complaints in these records, there's just a concern that maybe it's a little heavy on the evidence of the rape.
So when these medical records came in, both the EMT and the medical records themselves from the hospital, they came in by agreement after redactions that the parties engaged in. So
did the parties just not redact assailant, assault, all the different terms?
I was not, unfortunately, I was not the trial attorney in this case, but I have to assume that they both did a comprehensive review and made determinations. I think that one of the things that is clear from the record is that trial counsel, defense counsel in this case, was heavily utilizing the medical records in order to try to undermine the victim's testimony and to show that there was not evidence of injuries, that she was focused on discrepancies in the medical records versus the victim's testimony. And so
But utilizing, hadn't they objected to their admission?
No, there was no objection to the admission.
But there was an objection.
No, they were in by agreement. The only objection that occurred was the defense counsel's objection to the sane nurse's testimony when the Commonwealth was attempting to clarify the victim's menstruation status. That's the only objection to these medical records. And instead, the defense counsel utilized those medical records to try to undermine the victim's credibility, to say there is nothing in the evidence that supports the victim. This all happened in closing. None of the evidence corroborates the victim's story, and really heavily leaned on those medical records herself to argue her case. I do see that I'm now 10 minutes over time. If there
No,
are,
we want to keep you for another 8.
I'm happy to answer more questions if there are any.
No. Excellent argument. We don't mean to beat up on you. These are hard questions, and you've done a great job, both of you, really. And obviously, it's a complicated case. So thank you both for your excellent arguments. The case is submitted. We turn to the 4th case, after which I should say we're going to take our traditional mid-morning break. The 4th case is, fingers crossed, number 25-548, Commonwealth versus Hill. At least that's what they tell me on this list. And we will hear first from Attorney Weber.
Thank you. Philip Weber representing Mr. Hill. Mr. Hill's case is here today. As your honors are aware, 3 issues begin with the fact that the charge in relation to the incident on September 23rd, as your honors are aware, there was the charges from September 23rd and then the 24th, should have been dismissed prior to the trial commencing. As your honors are aware, the charges from that night ultimately
But
were...
under what vehicle? How was it dismissed before the trial beginning? Was there a motion to dismiss based on the lack of corroboration?
No, Your Honor, there was not a motion to dismiss, but I would argue that this is akin to a situation where the Commonwealth is not ready for trial. This is, I would say, akin to...
No, they had their witness. Just because they don't have another witness, which was evident from the defense closing, that the defense knew that. I mean, they get a chance.
Well,
What authority does the judge have to dismiss it at that point?
Well, I would argue that it is akin to Commonwealth not being ready for trial, because while they do have this witness, the witness was given immunity. And it's not as though the immunity was...
But you knew that before the trial started. You could have moved to dismiss these charges in opening, I think. Counsel says, note that all you're going to hear is an immunized witness. You could have moved to dismiss right then and said, Your Honor, they don't have adequate evidence here. And if they had said, oh, then it would have been dismissed. And then none of this stuff would have come in. But instead, you went through the whole trial without objecting to this. And then at the end, you say these have to be judgment of acquittal. And the judge agrees. I don't think you even ask for dismissal there, do you? Or for a new trial, or for mistrial, or for anything.
And I suppose trial counsel could have moved to dismiss, as I wasn't trial...
Should have.
Yes, Your Honor. Your Honor, you're correct. Trial counsel should have moved to dismiss. I wouldn't even necessarily disagree with that, and I suppose there's a possibility that maybe this should have been an ineffective assistance claim as opposed to what is before Your Honors, but I think it...
There's some procedural tangles here, but isn't the basic question that would make all those tangles go away whether the evidence of the September 23rd incidents would be admissible as prior bad act evidence in a trial solely on the September 24th charge? Because if it would be, then there's no prejudicial joinder and there's no issue about whether the September 23rd charges should have been dismissed, because he did get acquitted of those. So isn't that the fundamental question?
I do agree with Your Honor, yes. If that evidence would have been independently admissible on its own basis, then we would reach a point where any error would be harmless error, or, as Your Honor stating, it would have been able to come in for other means. So if it could come in as on its own basis, then yes, that would put us in that position. But I would argue that it isn't. It was not admissible for that reason, and which, as Your Honor correctly points out, goes to both this and the severance issue, because there really was no basis to bring that in under a prior bad acts type of argument. This type of argument, it's not that it doesn't show any kind of modus operandi because the two incidents.
No, it doesn't, but doesn't it show motive and intent or lack of accident, if you want to flip that around, lack of mistake or accident?
Well, I would say that in regards to the September 24th incident, I don't believe anyone actually claimed that it was an accident, what happened. I mean,
Well, no one knew what happened in the car. That was the theme of the closing. I mean, that was basically all that was left to the closing.
I would still argue that I just don't think there was the foundational basis for it to come in for those reasons. In terms of even being motive, I mean, there was already its own testimony that there were.
She goes in the car. She's in the car. He goes in the car. She comes out with a broken jaw. No one testifies precisely to what happened in the car. Is it not relevant that he had based on the events of the day before, he had a lot of animus toward her, and that she testified that when she laughs at him, she gets mad? He gets mad?
Well, I think it would be relevant to bring in the fact that they had recently broken up. I mean, there'd be some background in regards to their status, in regards to where the relationship was at. Some type of background in that would certainly be something that would be on the table, but I think there is a difference between bringing in some level of background about, we were a dating couple that had recently broken up, that there was evidence presented in regards to that they had a dispute between the two of them in regards to money. So if the idea is to bring in background to show that they have some type of conflict between them, that's something that could be in there. But I think it's quite different to bring in, because the allegations from the night of September 23rd are quite significant. And I mean,
Yes, they're massive. That's the whole point. I just don't see that they were, I mean, I see, and of course we'll ask the Commonwealth, I see them saying continuing scheme or course of conduct, although I think that's narrower than this. Identity, motive, intent, and lack of accident. No one claimed accident. I don't think there was an issue about identity. Maybe motive, I mean, intent, you punch someone in the face, I think intent is probably covered by the evidence of the act. Maybe motive. I don't know that all of this stuff has to come in, though, of the violence the day before. I mean, it seems highly prejudicial.
well, and that ultimately is, I think, would be the argument, Your Honor, that it is highly prejudicial because of how serious it is. And as Your Honor's pointing out, there were no arguments that it was an accident. To punch someone in the face, it's not really, the idea behind it is certainly that you are trying to harm a person. I don't really know of too many scenarios where you punch someone not trying to harm them. And the idea of just showing, well, these people have, animus or problems between them, I think there are plenty of options to show that well short of an incredibly prejudicial set of circumstances in which Mr. Hill is alleged to, have pointed a gun at her head, to have, basically trapped her in the home.
And pulled the trigger.
I mean, exactly, Your Honor. So I mean, this is something that it really would be the point of it, shocking the conscience. I mean, this is the kind of thing that a jury, I think, would have a hard time to be able to see past. And while ultimately it was directed out in the required finding, that means that it's not as though the jury, as far as we're aware, we don't know if the jury believed it or didn't believe it. Obviously, there's no final factual conclusions in that regard, but this isn't a scenario where they voted not guilty themselves as far as those incidents. This is something where they didn't get a chance to vote in regards to, because it was and correctly directed out in the required finding. So as far as we know, we have a jury who goes back, deliberates.
Do you argue that this is structural error, or only that it's a substantial risk of a miscarriage of justice? I mean, it wasn't preserved, right?
Well, when you ask if it was preserved, obviously the fact that it should have been dismissed, that there was no motion to dismiss, so that one I cannot say is preserved. But I would argue that the motion to sever, that issue, contrary to what the Commonwealth argues, I would
Yeah,
argue
but the
was
motion to
preserved.
sever, at the time of the motion to sever, you didn't know, did you, that you certainly didn't argue that there was no reason to put this stuff on because there was insufficient evidence of these crimes, right?
That was not the basis.
And you didn't know it at that time, so it can't be that the denial of that was an error because of the immunized witness issue.
Correct, Your Honor.
Right, so it's not, this claim isn't preserved by that.
Not on the basis of the immunized witness, Your Honor, no. I would still argue that even separate from the immunized witness portion of it, that it was still error not to sever the two cases. So even
I understand that, but I was asking about structural error or preserved claim, what it is we have to figure out. Look, I'm inclined to think that this stuff shouldn't have come before the jury. What do they need to know about the gun to the head and the pulling the trigger and these outrageous, terrible things that the defendant is alleged to have done? They're supposed to be adjudicating only the punch in the face the next day. So I have sympathy with that, but if the question is, was there a substantial risk of a miscarriage of justice, that gets to be quite tricky given the extreme weight of the evidence of September 23rd. Right, there's eyewitnesses, there's descriptions of lots of different things, there's medical evidence, there's the 911 call, I know you say shouldn't have come in, but it did, and that's, you know.
In regards to the 24th, Your Honor, I believe, correct?
Oh, yeah, the one of which he was convicted, but I'm sorry, I meant the 24th.
Moments myself were there.
So, no, I think there's strong evidence there. Now, I've never thought that strong evidence alone means there's no substantial risk, but it's part of it.
And, well, it's certainly part of it, Your Honor, and Your Honor's not wrong to bring up that those are things to be considered. I just think that the prejudicial nature of the allegations from the 23rd are just that strong. I think there is a substantial difference between an allegation of, if it's just the 24th, if all the jury is hearing about is the 24th, they hear an allegation that certainly, problematic in its own right, that, he goes, he punches this woman, he breaks her jaw, his girlfriend. That's one thing, but that compared to, and the night before, he'd held a gun to her head and pulled the trigger and trapped her in her home. I mean, that changes it from this singular encounter that may or may not have happened into this pattern of conduct from Mr. Hill. It turns it into, look at this problematic man that would, and you put that in front of a jury, I think it does put a lot of emotion comes in out of this jury thinking, well, we've got to stop this guy. This isn't some one-time thing. This is, look at him, he's on a rampage 2 days in a row, going after this woman. It kind of presents this picture of, if we don't stop him, he's just going to go and finish the job and go after it again, because those are two substantially different situations.
So the defense counsel said in the motion for relief from prejudicial joinder, basically, the 24th incident is a slam dunk, and it's going to pull the September 23rd incidents along with it, so you should sever. But the 24th incident, she says the evidence is overwhelming. And she essentially concedes that. She comes very close to conceding it in her opening. She says it's true. He punched her in the face in the car, and he broke her jaw. So even if it was error to admit, or an abuse of discretion to admit the prior bad acts from the 23rd, how is it prejudicial?
While I obviously don't have a perfect agreement with trial counsel's strategy, but that aside, I still think we're at a place where, despite the way trial counsel may have approached it, may have argued it, I don't think this was something that was.
But that argument is caused by the fact that she's facing all these charges. If there's only one, obviously you're not going to concede it.
Exactly.
If you figure, boy, does my client look bad, maybe I can give them one conviction, so they'll feel like they did something, and try to win on these other ones because this is a bad bunch of facts.
Certainly, Your Honor, because as Your Honor points out, if the counts had actually been severed, I can't possibly imagine that trial counsel would have gone in and described things the same way. Because
So you think that the evidence was not overwhelming?
At least not to the point where the prejudice from the 23rd does not have a substantial effect in regards to it. Correct, Your Honor. I do think there is still at least a question in regards to it, in regards to the situation. There's always the question of whether or not the jury believes the testimony from the alleged victim in regards to this. There's always that question in regards to that, and I think that to be able to go to trial, I do not think it was a slam dunk to the point that the incident from the 23rd doesn't have that prejudicial effect. I still think it is so significant that even with the evidence that may have been available.
At the time defense counsel was doing her opening, she knew that the victim had been immunized and knew that there was going to be no corroboration of that.
Correct, Your Honor, yes.
So even knowing that, well, maybe it doesn't matter what she conceded. The question is there a plausible argument that the evidence was not overwhelming?
And I'll say, Your Honor, certainly make me wonder if I should have perhaps presented an ineffective assistance argument based on the situation, but I would still argue that trial counsel presenting it in that way doesn't suddenly just remove the taint that comes from all the things from the 23rd coming in. Because I think once you have those things from the 23rd coming in, it just paints a completely different picture. I think a jury, if they hear about just the 24th, maybe they do have a question in their mind of, oh, is it that Mr. Hill did this, or is this just an upset ex-girlfriend who, something happened to her and she wanted to blame him? There is a question, there's always, a question in regards to, credibility. There's always questions that a jury would ask in regards to that. But it's one thing when a jury hears about one singular instance that was fairly brief. I mean, it wasn't a sustained thing. It was, one punch, which obviously a strong enough punch to break a jaw, so it's not a light punch.
In two places.
Yes, Your Honor. No, it was certainly, but quick in terms of time at least. So the question of, we have one quick encounter is certainly something for a jury to weigh and to consider, but it's a very different one to have this quick encounter combined with the night before him having supposedly, trapped her in her home, a gun to the head. I mean, I know I keep repeating gun to the head, but I keep repeating it because I think it is that strong and that damning of evidence against him that it just paints this picture of someone that the jury would feel compelled to find guilty and arrest that. And seeing where the time is at, unless Your Honors have.
Just one question about the 911 call. Serious bodily injury includes impairment of body function. Wasn't that 911 call evidence that she could not speak, which is essentially goes to an element of the crime?
It's not that it doesn't have any probative value, Your Honor, but I just think that there was already other evidence that would have presented that. So there is the issue that I think it would be, that there would be an element of it being cumulative, and even more than that, that there would be such a prejudicial, because her jaw was broken. No one was really contesting that her jaw was broken. And once you have a broken jaw, substantial bodily injury is just kind of a foregone conclusion at that point.
Broken jaw would be one substantial bodily injury. Inability to talk would be another.
Essentially, I would just argue that it's probative value in that regard.
Okay.
While there may have been some, I just think that there was plenty of other evidence that it was very low to the point where the prejudicial value of it outweighs any of that probative value.
Okay. I think we have your argument. Thank you very much. We will hear now from Attorney Wendell.
Good morning. I think it's still morning. May it please the Court. Assistant District Attorney John Wendell on behalf of the Commonwealth. Unless the Court would prefer I start somewhere else, I'll start with the dismissal question very briefly. I would like to first make the observation that the suggestion that the Commonwealth was not ready for trial is not raised in the defendant's opening brief, and therefore it's not properly before the Court. The argument is dismissal is permitted if there is not probable cause. Therefore, this should have been dismissed because the Commonwealth couldn't prove beyond a reasonable doubt.
So let's pull the camera back a little bit. Let's say the Commonwealth has probable cause, so they can get an indictment. But by the time trial comes around, the prosecutor knows, I don't have proof beyond a reasonable doubt of this.
Right.
Can they go to trial?
Yes.
Really?
Yes.
The Commonwealth can force someone through a trial knowing they don't have sufficient evidence. Tell me where I can find that written down.
Your Honor, I can't think of a particular case off the top of my head, but sufficiency of the evidence is only ever analyzed.
In this case, as a matter of law, you didn't have sufficient evidence. It couldn't matter what the immunized witness said because they're immunized and there's no corroboration, right?
But again, sufficiency of the evidence is only ever analyzed at the end of the trial.
No. Lawyers have ethical obligations.
I'm not...
Right, don't you think? You think going to trial knowing you don't have... What would the purpose of the government doing that be?
Frankly, Your Honor, the purpose would, in a situation like this, be to present a situation where the witness has the day in court to admit.
A witness has their day in court?
The witness.
You know you don't have sufficient evidence, but the witness gets to have a day. I think day in court is the phrase we use for the defendant.
It's used with respect to both, Your Honor.
I don't think we hold trials just so witnesses feel better if we don't have enough
I'm merely
evidence.
saying that there has definitely been a historical practice of, at least, I know this was a thing during the jury of 6 versus bench trial de novo era, of placing the witness on the stand when the witness is flatly denying that the incident occurred, so that there is specific testimony that the incident did not occur.
So that there can be an
After which-
acquittal.
After which there would ultimately be an acquittal. I am aware that happened.
That doesn't sound like this.
I will admit, this is a different situation.
You don't think you should have voluntarily dismissed these counts?
That's an interesting question.
I think it is.
Frankly, Your Honor, I'll just
I mean, they didn't, as I said, they didn't, I mean, I don't even know if it's raised right here.
Right.
They didn't, look, there's 8 where you could, if you only realized it at the end, you move for a mistrial, you say they've heard all this stuff, Your Honor. And if it's at the beginning and you say I moved to dismiss, there isn't evidence here.
Right, and I mean, I will say that quite frankly, and this is part of my argument that this specific argument is moot, the defendant's actually in something of a better position with respect to those charges. We'll get to the September 24th charge in a minute, but with respect to the September 23rd charges, the defendant is in something of a better position now than he would have been had my colleague moved to dismiss prior to trial, because that would have been a
That couldn't be more obviously wrong.
well, except that would have been a dismissal without prejudice. We would have been legally permitted.
I don't know. If you
charges
say
back.
to the judge, we're moving to voluntarily dismiss because we don't have sufficient evidence, why is that without prejudice? That
It's
sounds like
not
with
saying we
prejudice.
don't have sufficient evidence.
Well, that's
it's
what you'd
saying
be
we're not ready for trial. A dismissal because the Commonwealth is not ready for trial is a dismissal without prejudice.
I'm not saying you should dismiss it because you're not ready for trial. I'm saying you should voluntarily dismiss it because there is insufficient evidence that this crime happened beyond a reasonable doubt. Your Honor, this charge shouldn't have been brought.
And
we moved
again-
to dismiss it.
Assuming Your Honor's correct about that, the evidence may modify in the future such that the evidence is no longer insufficient.
Well, but it's the day of trial. You don't get you don't get to go, wow, we just realized on the morning of trial we don't have enough evidence, but if you give us 3 months.
I understand it, but any dismissal because the Commonwealth is not ready for trial is a dismissal without prejudice.
I'm not saying the motion should be on the ground that you're not ready for trial.
With all
You think that in the history of the Commonwealth there's never been an indictment issued, then further investigation that reveals, oh, we have the wrong guy, and you've dismissed the charge, right?
Of course we have.
Okay, and with prejudice probably, right? I don't know how you
Technically-
even do it. You don't even have to go into court. You
Technically, no, Your
Right.
Honor. A null process on the grounds that the Commonwealth has reached the conclusion, that is a discretionary call on the part of the Commonwealth. If the Commonwealth were to subsequently develop new evidence saying, oh, actually, hey, we were wrong when we did that, we would be authorized to bring the charge back.
I don't see how, if on the day of trial you know there's insufficient evidence, how you can have the trial.
We can't.
You can't.
In your footnote 3 of your brief, you cite this Commonwealth versus Hare case that
Yes.
says, while it's certainly a strong argument that when it's clear that defendant can't be convicted, neither the Commonwealth nor the defendant should be put to the trouble of the trial, but the SJC says the inherent inefficiency of such a trial cannot be cured by a method which creates even greater problems and which runs contrary to well-established law. So what are the problems that
The problem is that it's ultimately the Commonwealth's call to say whether the Commonwealth is ready for trial. What the defendant is suggesting here.
Why do you keep saying ready for trial? As a matter of law, which is not the Commonwealth's choice, it's the court's choice, they did enter a required finding. As a matter of law in this case, you couldn't convict because of the witnesses you brought. It's not that you had some choice here. You couldn't convict this defendant of these charges.
As a matter of law, the evidence that we presented on the day of trial was
There
insufficient.
are constitutional constraints on how long you can wait for trial.
There
So let's
are-
say you come up to the very last day
There-
on which you could possibly be ready for trial, and you say, we don't have sufficient evidence yet, So we're not ready for trial.
Then it gets dismissed on speedy trial grounds, and that is a dismissal with prejudice.
But otherwise, you get infinite chances.
If we are
The
not,
day that's scheduled for trial, you get to show up and say, we don't have, we have this immunized witness, but we don't have any corroboration. We're still looking for it. We're hoping to get it. So can we just kick the trial down the road a few months?
we could request that, yes.
How would that go?
I assume it would be dismissed because the Commonwealth is not ready for trial. That's what we're dealing with here. We're dealing with a situation where the defendant's argument, to the extent he's made it at all, is that the Commonwealth was not ready for trial. A dismissal because the Commonwealth is not ready for trial is a dismissal without prejudice as a matter of law. Therefore, the Commonwealth would, if we were able to come up with further evidence, be permitted to refile the charges, try the defendant on the charges, and potentially get a conviction where here he has instead been
Let's say
acquitted.
it had been, these charges had been dismissed. Let's get to the issue of whether evidence of
Right.
the 23rd would nevertheless have been admissible. Which exact issues? We often see the entire laundry list of permissible purposes for prior bad
Yes.
acts. Can you narrow it down for us?
This primarily, I would say, goes to motive and intent.
Intent in what sense?
Uh,
That his breaking her jaw in the car wasn't an accident?
Yes.
That it was an intentional?
Did she say it was an accident?
She did not.
Did
However,
did he say it was an accident?
He didn't testify.
But you still have to offer evidence.
I mean, accident doesn't seem like a live issue in this case. It's a punch in the face witnessed by a zillion people.
The problem, Your Honor, which, I mean, this is the problem that the trial judge keeps bringing this up with defense counsel. The problem is that the defendant keeps trying to keep evidence out on the grounds that, well, that isn't contested. And the trial judge's consistent refrain throughout this trial is there a stipulation? There is no stipulation. We
With
have
respect
to
to
prove
the
everything.
23rd.
With respect to the 24th.
To the 24th.
He says it with respect to everything. He keeps saying, is there a stipulation? And the answer is no, Your Honor, no stipulations in this case. That's the argument that's made with respect to the 911 call. They say there's no real contest regarding substantial bodily injury. And he says, well, is there a stipulation to that?
Okay.
And that is the trial judge's constant refrain. Is there a stipulation? No. Well, then the evidence comes in.
I just don't know. I don't see why you need to bring a past bad act in to show intent here.
Well,
Now, motive,
right.
okay.
I will say.
But motive, all right, so let me ask you, what was the motive of the punch?
The motive behind the
proved?
punch is a combination of the deterioration of the relationship and the fact that he gets angry with her when she laughs at him.
Okay. So, you could have put in evidence, maybe, that they just broke up. You
Yes.
could have put in evidence, maybe, that he gets enraged when she laughs at him.
Yes.
You can't put in evidence showing that he has a, what's the word I'm looking for, propensity to hit her when
Correct.
she laughs at him.
Correct.
So why can you put in, he held, I mean, I was shocked when I read this, a gun to her head and pulled the trigger
Right.
the day before. How can that be admissible? It's not necessary to show motive or, frankly, intent.
I will say that one is the most, that specific fact, the fact of pulling the gun out, holding it to her head, and pulling
That's the one
trigger.
I'd have been thinking about,
Yes.
aside from the punch in
right,
the mouth.
I will agree. That one is the one that is the most problematic in terms of prior bad acts. Again, I would say it goes to the intent, which conceitedly is the weaker of the two reasons for which prior bad acts evidence would come in this case. But it would go to the intentionality that he is, quite frankly, meaning to cause her very serious injury, meaning to cause her very serious fear in his actions in the course of this, what is fundamentally a 24-hour ongoing fight, as found by the motion judge.
Well, in the prior bad act jurisprudence, an important component of allowing prior bad act evidence, is the instruction.
Right.
Would you agree?
I would.
And best practice would be contemporaneous, but it has to be given at the final.
Correct.
And here?
Well, so the thing here is that ultimately the trial judge instructs the jury to disregard the evidence in its entirety.
Where? I looked for that, I couldn't find it.
I
And I saw that in the defendant's reply brief, but I couldn't find it.
I forget the exact citation. I believe defense counsel was correct, though. If I
saw the judge saying these other charges have been, you don't need to consider them, you shouldn't speculate about why, but I didn't see that it ever came up.
I think that would be the part that I would say that qualifies as an instruction that not to consider that. I do agree, though. The argument and the requirement of the instruction is typically a very important one. I would say the judge's instruction that they're not to consider the other charges, those have been gone.
If you find it, let us know.
All right. Fair enough.
Let me ask you again, this is a very specific category of cases. I mean, we know you can't impeach, you can't use acquittal evidence as prior bad act.
Correct.
You understand?
Of course.
And there are reported cases where judges have instructed that the jury has to find the prior bad acts beyond a reasonable doubt. Now, that's not required, but it has been looked favorably by the SJC.
Correct.
And earlier today, Justice Rubin was saying how he couldn't imagine if preponderance of evidence would be in the criminal jury instructions, but what is the Commonwealth's burden to prove that a prior bad act happened? And is this category of cases that where there's no corroboration, they're legally inadmissible, would that also bar these cases from even being considered as prior bad acts?
I don't think the jurisprudence is entirely clear on what the level of proof is for prior bad acts. Frankly, I was very sympathetic to Justice Rubin's questions earlier this morning about is there ever a point at which it's preponderance of the evidence? If so, how does that work? Frankly, I don't know what the level of proof of the prior bad act is. That said, I agree with my colleague's response that the ultimate crime must be proved beyond a reasonable doubt. In the subsidiary facts, the burden of proof is less clearly stated and in some circumstances may be a preponderance of the evidence. I don't know that it's clear as to the specific question of prior bad acts. I do agree with Your Honor, however, that we are not permitted to use prior bad acts for which the defendant has specifically been acquitted. So I see my time is very limited.
We've been known to go over, so.
Yes, yes. I was simply going to say I would think the best use of the remainder of my time would be to simply make the argument that this claim of error is not preserved because the defense argument was essentially, we concede the 24th, and this is in the original motion to sever. It's the 24th is a really strong case. It'll drag the others along with it, which is the exact opposite of the argument being made here. And
Well,
here
the
the
only
evidence-
real, if you want to call it concession, comes in the opening. It's a very strong case, is one thing. We
It is.
concede that it happened is
Yes, but
slightly.
The defense argument in the motion to sever is, this really strong case will drag the others along with it. That's the exact opposite of the argument that the defendant is making here on appeal. So this is not a preserved claim. And frankly, the evidence of the punch is overwhelming. I respectfully disagree with defense counsel about this being a very quick encounter that there's any ambiguity about. I don't know if Your Honors have watched the video yet from the parking lot. You can see the defendant very clearly lean into the vehicle. You see the entire vehicle shake. And she immediately gets out. She has a broken jaw, a very severely broken jaw. There are multiple witnesses to this. There's substantial corroborating evidence of her testimony. This video is very corroborative. The testimony from the store clerk, she makes clear she's been very recently, very painfully injured, cannot talk. The 911 corroborates her version of what happened when she attempted to call 911, corroborates the store clerk's version of what happened when she attempted to call 911. The evidence of this crime is overwhelming, and there's no other way to describe it. So ultimately, yes, conceitedly, some of this evidence from the 23rd, had there been a motion to dismiss, had the charges been severed,
Can I
probably
ask,
wouldn't have come in.
we've said, or the SJC has said, I think, that substantial risk of a miscarriage of justice doesn't mean necessarily that it would come out the other way. It means something like, Alpha says something like this too, that affecting the deliberations of the jury or something like that.
Right.
So if we think the jury couldn't help but have the unloaded gun pointed at the head and fired in their minds while they're deliberating, is that enough?
No, because again, the evidence is overwhelming. It's not so much the effect the deliberations isn't so much the jury couldn't help thinking about this. It's how much would it have actually made a difference? How much would the jury have cared? If the jury would have, as a result of that evidence, been far more likely to convict, where without it, they'd be sitting there for 5, 6, 10, 12 hours debating back and forth. I don't know, do we believe her? Maybe not. How well corroborated? If we have that without this evidence where they convict him in 2 hours, that would be a substantial risk of a miscarriage of justice, potentially. But if it's, oh, we think about this guy's a little creepy, we don't like him, but oh, hey, look at this evidence is overwhelming. We really just have no question, because even without that, this is just, look at all this video, look at this 911 recording.
That's a pretty good answer.
So I would...
Just very briefly, there was a lot of discussion earlier about whether the Commonwealth could go forward knowing there was insufficient evidence. We don't know that's the case. The record's not clear whether there was a mistake of law or is it? Did I miss that? The record's not clear why that happened from the Commonwealth's perspective.
Regarding why the Commonwealth proceeded to trial?
Knowing or without sufficient evidence.
The record is not clear. I believe the simple answer to that question is that my colleague either disagreed with the trial judge about the specific application of that law to this specific case. There's an argument to be made.
The record's not, that's not in the record.
Right. There are arguments to be made.
Maybe no
either way
lawyer
on
in
that.
the room knew about this law.
Right.
Because it's being argued explicitly by the defense in opening.
Right.
When it
There's an
supports an immediate motion to dismiss a bunch of
There's an
counts.
argument to be made that my colleague disagreed with the judge regarding the specific application, that it simply had not occurred to her until after trial was underway. I can't say that's not in the record. I wish I had an answer to that question, to be frank.
All right.
Also.
Thank you. If there are no
Okay.
further questions.
Only 4.5 minutes over time. Thank you both very much, and thank you for
Thank
the
you,
extra
Your Honor.
time you've given us. We are going to take our mid-morning break, as I suggested, and we will be back in 5 to 10 minutes to hear the 2 remaining cases.
Testing, 1, 2, 3, testing.
Oh, I don't hear anything.
Te-
Maybe I'll just stick with
Testing,
that
1,
one.
2, 3, testing.
Is it not on?
No, it was. Yeah, I got a yellow light, so it should be on. Testing, 1, 2, 3, testing.
No, I'll
Nothing?
stick with that one. I can
Okay.
hear. Thank you.
Yeah, we know that one works.
Yeah.
Court is now in session. Please be seated.
Good afternoon. We resume our admin schedule with number 25705, Commonwealth versus PINA. And we will hear first from, it is a partially impounded case, so whatever's impounded, don't refer to. We'll hear first from Attorney Rogers.
Good afternoon, Your Honors. My name is Mary Rogers, and I represent Lisa Peina. Ooh. I have a listening device to help me hear.
It's fine. Is it, but if it's feeding back and that's a problem, that's no good for you. We can hear you, so.
Okay,
Let's see how it goes, and if we need to adjust, we will, of course.
okay. I can adjust too, apparently.
Okay.
But I could hear quite well with this. I'm glad I was given it. It's awesome.
I'm glad too.
Yeah, it makes a big difference because I want to make sure I answer the questions that you are asking me. Yeah.
Interesting. All right.
This is a direct appeal, but before I proceeded with the direct appeal, I filed a post-conviction motion for required finding or lesser included and a motion for a new trial. So when I received this case, it stood out to me about these blind spots, and I wanted to look into it further. And when I looked at the docket, I saw that motion for funds had already been allowed in the amount of $2,500. Ms. Peina originally had a different attorney, and then when she switched attorneys, that attorney did not notice that being in the docket and available. And I filed an affidavit, and he said he didn't even consider hiring.
Respectfully, I think we've got the factual
You got the
background.
facts.
So we know that the judge found deficient performance, but no prejudice, because he said the negligence was that she wasn't looking around for the 7 minutes that she was sitting in the car.
Okay. So I'll cut to the chase more on the prejudice part. And I don't know why it's doing that. So it was basically uncontested as to the report that was filed. Can you hear me?
Yes,
All in
perfect.
clear,
Oh, okay.
yes.
Let me know if you can. It's disrupted my thinking.
You were going to talk about the prejudice prong because the judge had found the first prong satisfied as Safarian.
And I don't think that's in dispute. And also not in dispute is the report that I filed, and that it was very well done with diagrams. They took the mapping points from the Commonwealth's experts, used them. The diagrams that I provided to you, I think, are very telling, especially on page 23.
Can I ask you, under the Safarian second prong, under the prejudice framework, why do we even get to blind spots, pillars, if the basis for the judge's conviction was not based on that evidence? He found a different ground. So why are we talking about?
He says he found a different ground.
Yes, he did. Do you want me to jump to that portion?
Certainly.
Okay, so I point you to page 45 to 47 of my opening brief, and in there I cite two cases. When I got that decision, I'm like, where is this coming from? No one even argued it. And so I said, I don't even know if there's a case out there, but yet I went searching and searching, and eventually I found two cases. And on page 45, I discussed Cunningham versus Thurman Transportation, Inc. And in that case, there was a child that was below the level of what you could see.
But I just want to interrupt you because that again is relevant to whether or not the blind spot new evidence may have been relevant in the trial. But the judges are saying essentially there is a separate basis for this guilty verdict, and that is the inattentive negligence, which is being described as. So as the fact finder, do we disregard that?
Oh, no, I don't mean that. There is no case. There is no duty that when you're sitting in your car, before you start it up, that you have to be paying attention to everybody walking around your car. Have in mind that somebody might fall drunk, flat in the road, wearing dark clothes in the shade. It's just not something that people contemplate.
Let me ask a different related question. It's really, I'm trying to get my head around the framework.
Okay.
Because it seems like if we're talking about negligence, or if we're saying maybe the operation element wasn't established, because the judge seems to say that there was negligence then operation, these seem to me to be sufficiency of the evidence claims. There wasn't a sufficiency of the evidence, a Lattimore claim brought here, but we're at second prong Safarian, and there's different articulations of the standard, but it's whether this defense, this bolstered new defense, well, let me actually quote so I don't misquote. In Millian, you cite in your reply brief, which is a helpful case that equates the substantial risk standard also with the second prong Safarian, but one of the formulations of substantial risk, which again is the same as second prong, is that counsel is ineffective for failing to present an available ground of defense. That defense is substantial for Safarian purposes, where we have a serious doubt whether the jury verdict would have been the same had the defense been presented. This judge is saying there isn't a serious doubt because the verdict didn't rely on this blind spot theory. It relied on a different theory. So how do we get from second prong Safarian to sufficiency of the evidence?
That sounds kind of intertwined. It sounds like in the background you're wondering, why am I not arguing required finding?
That's a different question. I mean, you essentially have argued by arguing that negligence wasn't established, that operation may not have been established. That could also have been packaged as there was insufficient evidence for the verdict. But that's not before us. What's before us is whether the failure of this judge to consider this new evidence satisfies the second prong.
I don't know what the judge's original thinking was, because this was all new when we got the decision. Nothing like this was argued at the, he had an oral argument on the motion and decided he didn't need an evidentiary hearing. So I'm not arguing that it's a required finding because there was a 10-foot ability to see the person.
Well, yes. I mean, that seems clear. I guess what I'm trying to figure out is, I don't see how required finding is the issue, since this blind spot evidence wasn't in, right? So the judge didn't, the judge's information was what the Commonwealth said, which is 10 feet before you can no longer see where the body was. If, in fact, the car was parked 30 feet away, and that's an unknown, actually. So, but, so the judge says, wow, you didn't do this, reconstruction, and if you had, you'd have found this blind spot. You should have done that, and you should have found the blind spot. And then the question is like, well, did that, it's essentially create a substantial risk of a miscarriage of justice, same standard. Did that deprive the defendant of a substantial ground of defense? Now, if the judge had said no words, I'd quite clearly, well, I don't know if everyone would, I don't think they would, but I would think, yeah, of course it did. The point was that she could see the person, yet ran over her, And this says she couldn't see the person. And that's a completely different question of negligence. If you can't see someone, you're not being negligent about it.
Right.
But the judge doesn't say that. The judge says, speaking only of himself, not of what a rational judge would do or objectively what a finder of fact might think. He says, I would have convicted her anyway because she was negligent in not looking around while she was in the car, not being aware of her surroundings while she was in the car during the 7 minutes, or really the 37 or however many 40-something seconds, during which the decedent crosses the street and falls. My question, I think maybe this is what Judge Smyth is part of what he's trying to get at. My question is, do we care what this guy would have found? Or are we supposed to figure out what a reasonable juror would have found? Because, I mean, there are then other questions like, can it be negligent to not be looking around your car while you're in it doing something else, and so on. But let's start with that question. Do we look at what this judge would have done?
No. And you have a case on that, Your Honor. Commonwealth versus Tompkins, which is cited in my reply brief.
Yes, I was on that case. It is an unpublished case, of course.
It is. And I provided that in the follow-up to that where the motion for new trial was granted. When it was submitted back to the trial judge, you made clear that when the judge decided it was to be by an objective standard with a reasonable finder of fact coming freshly to the case. And that was a point I wanted to make. It's really important because the judge, in my mind, kind of after the fact, he said, hey, I could have found another ground, and it was just like fishing for it. But when you think about it, how many times is someone driving down the road, they say, I got to make a phone call, they pull over, they stop, they make the phone call, or I got to check that text, or I need to get directions before I drive. I have to pay these bills because it's due, and I got to get my check to my landlord, and I could do that online. There are so many things. So negligence requires reasonable care, ordinary care in the circumstances.
But before you continue about the negligence, getting back to Justice Rubin's question, you cited Tompkins, and you're saying it should be an objective standard. Now, the SJC knows how to say when an objective standard is required. There's a category of cases, post-verdict, where there may have been extraneous influence on a jury, or the jury might have potentially been tainted by racial deliberations. And there's a long process, but the final process for determining prejudice is whether the hypothetical reasonable jury would have been impacted or infected. It's not that jury. But when I look at all the substantial risk or the second prong Safarian cases, they seem to be talking about the particular jury or judge that heard the case. There's no objective language that I can find, or I haven't found any cases other than Tompkins. When I read Tompkins, the objective language that's supported refers to the first prong, where we review an attorney's conduct objectively. In the second prong, there is a cite, but I'm not sure the precedential value of that other cite, so I'm not sure there are any cases, and I think the Commonwealth agreed with you. I'll ask them next on Tompkins, but I'm not sure it's settled case law that we have this objective standard and we should ignore what the fact finder found.
Yeah, we're talking about apple, oranges, and grapes. I mean, there's so many different questions it raises, but no, I think you need to look at what this judge said. Hey, if I was the fact finder today, this was presented, I'd give it more thought. I'd come with a different decision based on something else. Definitely you need to look at that because he's a reasonable person too. But is he looking at it objectively or subjectively? his decision is not founded in solid law. He made two legal errors. One was he didn't get the standard right as to what the duty of care is. There is no duty of care. If you issued decision...
Well, that's not really established by the cases. I understand cases may not have recognized that that in this particular situation, it's negligent or not negligent not to look around your car. But generally, negligence, has a heavy component of fact to it, and it's up to the jury or the fact finder with the, applying community standards to say what was reasonable in these circumstances. And so the fact that there's no case saying this was or was not negligent seems to me doesn't preclude the fact finder from finding this particular conduct to be negligence. Not everyone would agree with that.
I agree with you. This is apparently a case of first impression. I say there's no case because, to me, it's obvious, but it's what the judge found, so of course we have to look at it. There has to be circumstances. All that the judge cited was D'Angelo and Jones. And I looked at those cases. One was, it was a corporate criminal
They don't
liability.
establish as a matter of law that this kind of conduct is negligence.
Right. And the Commonwealth has not found any case that even comes remotely close.
Right, but there's no case that says this isn't negligence either.
No, I wish there was.
So
but-
it's kind of, where it's up to the finder of fact, do we take the judge's word for it in his decision denying your motion, or do we have to go back and say, no, this whole body of evidence has to be presented to a new fact finder? Or we need to think of what would happen if it were presented to a new fact finder taken afresh, and is it reasonable to think that it would have made a difference?
Yes, I would go with what you last said, that you look at the question of, was this negligence just by merely sitting in a car and not paying attention to a woman walking way far back there and staggering some, carrying a pizza box and subs, and then not until you get up here that you could most likely even have noticed. And if you're looking at your phone or whatever, but then before you take off, you gotta look in what's coming from behind, look in your mirrors, look straight ahead. It was a one-way street. It was on a curve, which is important. Do all the things that you're supposed to do, and then start your car and go. And if you would have ruled that that's negligent, then every time someone's sitting in a car, this was a residential street, you could see not lots of traffic, some traffic. There was nothing to indicate negligence. Now, I gave you the example, which is what came to my mind, is if the circumstances were very different. Suppose you go to pick up your friend at a bar, and it's a well-known bar, and it's a busy bar, and there's people coming and going. It's 2 o'clock. It's dark out. There's people congregating and talking amongst themselves, congregating. Some people are walking this way, that way. Somebody runs by. It's a very busy happening when people, I think you could say more than likely, a lot of them have been drinking. If that were the circumstances and someone was not more careful in some way, then that would be different. You have to have extraordinary circumstances.
Okay, I think we understand the argument about that. Your time has expired, but I want to, it's a complicated case.
Here.
I guess I have one other question.
Yes.
If the leaving the scene conviction is not reversed, there's a 1-year mandatory minimum in this case, regardless of what happens in the negligence case. Is that right? Okay.
That's correct.
All right. Thank you very much. We will hear next from. Well, that's a perfectly good question, isn't it? I believe we'll hear from Attorney Knight.
Can I say just very short on the legislative intent?
No, I'm sorry,
Okay.
but we have your argument.
Okay, and the 16L with
We
Commonwealth
have-
versus Hill.
We have
Thank
that.
you.
Thank you.
Good afternoon. I don't know that I've said that very often in this courtroom. May it please the court. Erin Knight on behalf of the Commonwealth.
Can you move the mic a little closer to you?
Closer? Sure.
Yeah,
Erin Knight on behalf of the Commonwealth. With me today is the trial prosecutor, ADA Nathan McGregor. And first, I'd like to recognize the family of the victim, Brenda Keller, who are watching via the live stream today. One thing I do want to point out before we do get started is that in all of these claims, the defendant does not make a claim regarding the third count for which she was convicted, the tampering with evidence count, either here or at the motion for new trial. So as it is, that count stands no matter what does happen today. I want to start off with Justice Smith's question regarding the objective category of looking at this. Yes, you are correct. It is the objective look at whether at the time of trial or at the time the decision was made, this attorney was ineffective, and he did that here. In fact, he found him ineffective. The Commonwealth does not concede that, but he did. He found him
You also
ineffective.
don't contest it.
Actually, in my brief, I do write that we don't concede it.
You write that you don't concede it, but you don't explain why it's wrong or contest it
Well, at this
substantively.
juncture, we're proceeding with the theory that he did
Okay,
find
so go-
that,
oh, yeah,
so
sorry.
I don't think it is proper for me to go
Well,
into
you
that
can
right
argue
now.
about legal conclusions people draw, but go ahead.
So anyway, so going on to the second prong of that is where you almost have to get into subjective. It is the process in this Commonwealth that if a trial judge is still sitting, the motion for new trial goes back to him. In fact, we always this court gives deference to a motion judge
So
who
this
was
is
a trial
Safarian's
judge.
second prong.
I'm sorry?
This is Safarian's second prong.
It is.
And so probably you looked at the Tompkins case because it was cited even though it's unpublished.
I did.
And it cites a Court of Military Appeals case.
I do, yep.
And I think even the parenthetical may mention that it cites Supreme Court cases.
Mm-hmm.
And the Supreme Court case it cites primarily is Strickland versus Washington. Are you familiar with Strickland?
Yes.
Okay, here's what Strickland says. In making the determination whether the specified errors resulted in the required prejudice, that is the second prong of Strickland, which is, how would I put it? We say that our test under Safarian is at least as protective of a defendant as this one, right? That's what we say about this is ineffective assistance of counsel also under the federal Constitution. A court should presume, absent challenge to the judgment on grounds of evidentiary insufficiency, that the judge or jury acted according to law. The assessment of prejudice should proceed on the assumption that the decision maker is reasonably, conscientiously, and impartially applying the standards that govern the decision. It should not depend on the idiosyncrasies of the particular decision maker. Although these factors may have entered into counsel's selection of strategies, and to that limited extent may thus affect the performance inquiry, they are irrelevant to the prejudice inquiry.
And I would say, Your Honor, with that quote, counsel's decision-making of the decisions of the fact finder, or I apologize, I'm not exactly saying it, at the time. If you go back and
Yes,
look
that's
at,
for prong one, for did it fall below. But for prejudice, we don't look at the particular decision maker under Strickland. That's a published case, not an unpublished case. It's true it's Strickland and not Safarian. Now, maybe I'm reading that wrong, but to me that says it's an objective standard. What would a reasonable fact finder do?
then how do we ever get a bench trial with a motion for new, or a bench judge with a motion for new trial, right?
If the judge's conclusion about the impact is a reasonable conclusion.
I think
suppose.
what-
I mean, you cited Tompkins in your brief, I think, for the proposition that when we look at prejudice, we look at what a reasonable fact finder would have done. And that's what
I
you
understand
said.
how that is. I understand how that is construed. What I am citing it for is the theory that looking at this case, should this have been, and if you correct me if I'm wrong, I think Strickland was a jury case. If the fact finder, or excuse me, the motion for new trial judge is looking at what a jury would have done, where they don't have that information of why a jury found the way it did, that has to be objective. Here, we have the benefit of understanding why the judge did what he did.
No,
And
we
quite
have the
frankly,
benefit. We have the benefit of him saying what he would have done, not at the time. This evidence wasn't presented at the time. What the judge said here is, had I known of this evidence, I would nonetheless have convicted because it's negligent not to know your surroundings when you're in a car.
Correct.
He didn't say that's what I decided. He says that's what I would have decided.
Okay, so
There was no reason to decide that because he had evidence that she could see the body right in front of the car.
I entirely agree with you, and that's why, quite frankly, this probably is a red herring. But to finish this thought, just to make this clear, the judge goes into what he found at trial to make clear, or why he found the way he did, or part of why he found the way he did, to make clear that this blind spot that she's raising, which was the only issue raised as to the negligent homicide count, didn't matter and wouldn't have mattered, okay? And so here—
To him.
I'm sorry?
To him.
Or
No,
looking
he
at
said-
no,
he said
looking
to-
at, Your Honor, looking at the standard here, it's outside the range of reasonable alternatives. And quite frankly, where there was information presented about blind spots, a third blind
I don't
spot—
think it's outside the range of reasonable alternatives. This isn't
it's
an
an abuse of discretion standard.
No, it's a legal question whether a substantial ground of defense was made or not. Would it-
Correct. And his decision, which you are to review, is based on an abuse of discretion standard.
No, it's a legal question. It's de novo.
Can I ask you about another Strickland quote? It's at page 695, 466 U.S. 695. It says, evidence about the actual process of decision, if not part of the record of the proceeding under review, should not be considered.
And that's because oftentimes it comes from a jury
Right,
and we don't have that
but
information.
when evidence of deliberation is available, is your inference we are to consider it? Or is that your conclusion?
I don't see why you wouldn't. And I think it's fine to do that because—
Do you have a case?
Can I please finish?
Yeah, go ahead.
I would say because, again, what this judge decided wouldn't be outside the range of the reasonable alternatives for a fact finder to find. We are focused here on whether or not the defendant's single blind spot that she put into her motion for a new trial affected his decision-making or affected a decision-maker. Here, he went a step further, perhaps because of this case in specific, because this case was he called it a close call. And he wanted to explain to her that the reason the blind spot doesn't matter to me is because I found for negligence. And he said at his findings, at the trial, when he found her guilty under the negligent operation homicide. He did not find an accident. And so therefore, him giving explanation to her as to what she's bringing up on a motion for new trial doesn't take away from the fact that this is a reasonable finding, that this could be, any fact finder could come to this conclusion.
I guess the question is that binding on us? Where the judge says after the fact. I mean, he doesn't say it when he's announcing the verdict because
Correct,
this long discussion there is all about ID.
It was at ID, yes.
So in his decision on the motion after the fact, he says, well, it wouldn't make any difference because I found her negligent on a different ground entirely. Not the blind spot, but her failure to watch while she was in the car. Is that binding on us, or do we ask whether a reasonable fact finder coming to all the evidence freshly would whether we have some doubt about what the fact finder would do in that case? And it seemed to me like in your brief when you cited Tompkins, you said the court considers the question objectively, although it's worth noting what the judge said. So that's one perspective, but is that binding, or can we say we have some doubt about whether this was we think it might have been a substantial ground of the defense. The judge himself might have been sure that it wasn't, but can we do that, or are we bound?
So my answer to that is it's complicated, right? And I think Tompkins makes it complicated because my reading of Strickland, and I Judge Rubin, I understand that you read it differently. My reading of Strickland is that it only applies to that first prong of Safarian. And here, what we have is a motion judge giving a little bit more than he even needed to give. And so how does this court punish him for explaining himself?
He's never punished.
Okay.
There's a defendant and there's the Commonwealth. We don't punish judges. We try to make sure the cases are done fairly in front of them.
How then would you expect in this situation a motion judge to completely disregard everything he learned from trial to say it has to be objective.
Well, maybe it's a red herring, like you suggested.
I
So
think
why
it
don't
is,
we
Your
go
Honor.
to the next question, which is, what is the duty of care while you're sitting in a car, not driving it?
The duty of care portion, and what he's getting at, is the fact that a duty of care is owed to all pedestrians, to all other drivers, by a driver. This is a person who, whether or not they're sleeping, they're putting makeup on, they're doing anything, owes a duty of care to those around them as they turn that vehicle on and pull out this piece of heavy machinery to have looked around and make sure nothing is in the way, no one's going to get hurt.
What if it's in a blind spot? What if they can't see it from the car?
Then that would be an accident, but that's not what the judge found here.
That's not what he found, but we're trying to figure out if there needs to be a new trial in light of the fact that now there's evidence that suggests it might have been a blind spot. So you're saying if it's in a blind spot, his reasoning is no good.
I'm not saying that.
You
I'm
just
saying
said
if
that
it's-
would be an accident, not negligence.
Your Honor, please. If it was in a blind spot, she has a duty to check those blind spots. But what I would say is watch the video in this case. There is a reason he does not believe that third blind spot mattered, and that's because the testimony at trial from the Commonwealth talked about the potential for the hood and the A-pillar. It talked about turning. It talked about 20 feet, having 10 feet of visibility. We also have to remember that this woman, a full-size human being, was laying in the middle of the road at an angle from where the defendant was parked, who had 38 seconds between when the woman fell and the defendant ran her over to have started her engine and looked around. The judge implicitly here must have found that she should have or could have seen that woman.
I want to be sure not to interrupt you. What you just said is a complete contradiction of both of what the judge said and what you say in your brief. You say that it is negligent when you're inside a car not to see someone walking and fall down if they fall down in a blind spot. That's what the judge said also. Now you're saying she could see her from the car. The point of the evidence is, and I'm not saying the evidence is right, although you didn't contest it below, but the point of the evidence is she couldn't have seen the person from within the car. Do you agree that if she couldn't have seen the person from within the car, she was not negligent?
I do agree with that, and that is not what he found. He found that she was doing something to have caused not seeing this woman, not that she could not have seen her, is that she should have and did not.
Wait a minute, should have while she was lying on the ground flat, or should have seen her fall?
Should have seen her coming down the street and fall. Part of that is the falling.
Have you ever driven on a highway?
Your Honor, I have.
Okay. Have you ever seen a sign that says, like, if you're tired, pull off the road?
Yes.
Do you think when people do that, maybe they go to sleep in their car?
Yes,
Do you think they ever miss something that happens outside their car?
of course.
Are they negligent if they
They
don't
are
get
if it then causes issue. They are if the car is running and it's in operation. They are if they pull out and they don't look where they're going because of the activity they were just
You're
doing.
not answering my question, which I think is pretty clear. If the person is lying in a blind spot, are you saying they have to get out of their car, walk around to see it because they were asleep and someone could have fallen? Because that's the only way someone could see something in a blind spot if they'd been asleep when it landed there.
No,
You're not saying that.
I'm not saying that.
So how is the sleeping person supposed to know there's someone in the blind spot?
Because, Your Honor, they still have a duty of care to look around. If she could not see her, you're right. However, that is not what the judge found.
Is there a duty of care established as a matter of law by some cases, or is it up to the fact finder? I mean, isn't negligence often a question for the fact finder?
It is. Negligence is often,
So maybe-
based on facts and circumstances,
Sure,
mostly
and the
circumstantial
community bringing
evidence.
its standards to bear on what kind of care we expect of people. So some people might think, yeah, if you've been asleep in the car for 7 minutes, you need to get out and check and make sure that there's no obstruction when you drive it. Other people might say, no, that's not negligent. That might be great in a world where everyone needs to take every possible precaution before moving, but it's not reasonable given everything else that everyone needs to get done in their lives. So reasonable people could differ on
Absolutely.
whether that's negligence.
And what I would also point your honors to is a lot of the cases that my sister cites to do with children and often being under a tire or behind where those blind spots are
so they
known.
don't
This is a
establish-
fully grown woman lying in the middle of the road.
Right. But would a reasonable jury necessarily have found this to be negligent, or could reasonable juries or finders of fact differ about whether this
They could, but this, and that's the standard, is that it's not outside the range of reasonable alternatives.
It's a legal question whether you have to get out of the car to show reasonable care or whether you can sit in the car and if something's in a blind spot, it's an accident. It's not about ranges of reasonable alternatives.
Excuse me, if I may finish.
Please.
I see my time has
As
expired.
you may have noticed, we aren't very rigid on the...
The standard that you go through to determine if this motion for new trial was improperly denied is abuse of discretion.
Sure.
And
But that contains within it, if there is an error of law, it's an abuse of discretion to rely on an error of law. Would you agree with that?
Yes.
Okay, so I don't know that there's really a lot of daylight here on the standard.
I don't think we're disagreeing at all.
Right. I'm just hoping that I'm making my point that there are more than one way to look at this, and I would specifically point to page 6 of his decision. He talks about how the defendant's new trial motion is premised on the notion that her only negligence was to pull the car away from the curb and run over someone. In fact, defendant was negligent in other ways, having nothing to do with the blind spot. Then he goes into that 30 seconds. So I would also say, Your Honors, and looking at the video, this is a fair inference, he found that she was negligent in pulling away because he said that's not her only negligence. In fact, she was negligent in other ways as well. So I think here, again, I know we need to go through this, but I think here, just because he enumerated something that had nothing to do with the blind spots to kind of counter what she was saying in that I consider the blind spots, this doesn't necessarily matter. He's also not saying that's the only negligence he found.
I had a couple questions. I realize we're over time, but I'm still trying to get a good grasp on the framework here. So under second prong of Safarian, we're to go back and review whether there's sufficient evidence of negligence under the judge's theory.
Are you asking if you would go back?
Asking you, yes.
No, I don't think it's a sufficiency claim. I understand how they may be,
Well, I'm not saying it
in
is a
theory,
strict-
being intertwined.
Right.
But what here is, did he mispresenting something that would have been a substantial ground of defense, correct? And so here, the judge is saying blind spots were considered. A third one here, and looking at the information, he had all of the information from the defendant's accident reconstructionist. It's a very thick packet. He had all of that information. He went through it, and he said, no.
So when we're considering whether there's a serious doubt whether the result might have been different, again, do we stop at, well, the judge found another ground, or do we then proceed, but that ground he found is vulnerable because of these reasons?
Quite frankly, Your Honor, I think either way you look at it in this case, whether or not you credit what he said and go because of that's what he determined, or go from a completely outside perspective of somebody, a hypothetical jury or another judge. Quite frankly, the information that was presented was just that there was another blind spot when he had already discredited the fact that she couldn't have seen her. And if the court has no further questions, I'll rest on my brief.
I see none. Thank you very much. Thank you both. The case is submitted. Our final matter for this morning is number 241446. This is GUZ versus Hyestan Industries. You may proceed.
May it please the court, Your Honor, my name is Joel Feldman. I represent Angela and Christopher Guz in this cross appeal. They're requesting that this court affirm the housing court's decision under 93A in Chapter 186.14, and that the court remand the housing court's attorney's fee decision for a new decision based on Massachusetts law. Your Honor, the appellant only appealed the fee issue, so I'm going to begin there for a few minutes, and then I'll address the underlying claims and whatever other questions you may have. Your Honor, the trial judge determined that the attorney's fee assessment was based on the amount of, the fact that the amount of time spent litigating this case appears to the judge to be disproportionate to the interests at stake. We disagree on two basic grounds. The first is that the judge did not consider all of the interests at stake. Secondly, the judge did not use the lodestar method in determining the attorney's fee. Addressing the interests at stake, Your Honor, it's foundational law that under Stratos in particular, that the very reason for fee-shifting statutes is because while they are not likely to pay for themselves, they are nevertheless desirable because they vindicate important rights. The important rights at issue here were under 93A and 186.14. The legislature, in its wisdom, determined that they were going to attach fee-shifting parts to these statutes for two reasons. In general, that's what the cases say. One is to incentivize lawyers to do these cases and to disincentivize wrongdoers from engaging in their wrongdoing. The court didn't consider that at all in its decision. Rather, the court essentially looked at the math of this and said, oh, the tenants only recovered the tenants only recovered $600 under 186.14 under the statutory damage component, and therefore the $12,000 fee request is disproportionate. And so the court essentially cut 75% of the fees solely because of the amount that was recovered in the case.
I understand your point about the judge at least not explicitly having considered the value of having counsel represent tenants who are facing eviction and successfully defending against an eviction, apart from the damages. I wanted to ask, in the first action, the judge concluded that failure to comply with Section 32J invalidated the notice to quit, basically. And that was based on an argument that the tenant made as early as the, I think, the answer, or perhaps the counterclaims in the first case. So
the first case between the parties.
First eviction,
yes.
Right. So, but then the judge decides later, sometime in the second case, I was wrong about 32J. He reverses course, and we, in the prior panel decision, agreed that that was incorrect. So could the judge consider here, among all the different factors, that the tenants had, in a way, led him into error on in the first case, and that should somehow affect the attorney's fees award?
No, that shouldn't, Your Honor, because the judge made a determination, the judge heard the parties, the judge made the decision, and the judge issued his decision, and then the landlord ultimately had many options to go forward in the second case. For example, the landlord could have said, I want the tenant to pay $2,000, and the tenant refuses. So there were a number of cause issues that could have been raised. What they raised in this case instead was they said, the tenant, this is a non-payment of rent case for $1,000 a month. The tenant, it's undisputed that the tenant never agreed to pay anything like $1,000 a month. Instead, the court found, as a matter of fact, that the parties had reached a rental agreement for $217 a month.
At what point did the second notice to quit get served in the context of the first litigation? In other words, did the landlord do it as soon as he had the option?
The landlord did it, Your Honor, the landlord did it in 2022. And the original case was brought, I think, in 2021.
Well, once the judge decided that there was noncompliance with 32J, how long did the landlord wait before bringing the second action?
Your Honor, I'm not exactly sure of when the decision came down at the trial court and when the next case began. It's not in this particular record. In any case, Your Honor, by virtue of the fact that disproportionality was the only issue that the court looked at, the result is that a tenant who would be paying, let's say, $7,000 a month living in a condo in Boston, triple damages would be $21,000. And this court apparently wouldn't have had a hard time with that because $21,000 is more than $12,000. So tenants who can afford more and have higher incomes are going to be okay getting their lawyer, and they're going to be okay spending 30 hours on a case. A tenant like the Guzes, who paid $217 a month and who are low income and disabled and living in a mobile home park, they get a lawyer for 8 hours because that's what the judge determined here. The request was for $400 an hour. The court said, you get $3,500. That's less than 10 hours. Presumably at that point, the lawyer is supposed to say, oh, whoops, I've spent too much money, I need to stop, I can't go forward because otherwise I'm doing this pro bono. Remember, the statutes were enacted in order to have private attorneys general, that is, private lawyers to enforce the important rights under the statutes. With this judge's determination, there's a two-tier system. That is, if you make a lot of money and you have a high rent, you're okay. If you make a small amount of money, have a low rent, you're not okay. Additionally, trying to cut off the amount of hours that a tenant's lawyer can work on, and this, remember, this was in the case, I want to reiterate, the Guzes did not bring this case. This was an eviction case brought against them. So beyond the interests at stake in general through the legislature, their interests were in not getting evicted and potentially being homeless. Their interests were in not owing $18,000 of rent that they had never agreed to. They prevailed on both of those issues. They then prevailed on both of their counterclaims. And in the course of this litigation, as you can see from the fee hours, which are part of the record, the landlord, appropriately so, zealously litigated this case. When the judge decided on summary judgment that the tenants shouldn't automatically win under 93A and 186.14, that there needed to be facts determined about why the landlord did this, the tenant's attorney tried to take a deposition. The landlord moved for a protective order. The tenant had to go into court in order to get the deposition. The deposition started. The landlord wouldn't answer any questions. So we went back to court on a motion to compel. So this was part of what happened here, and City Rentals says this, that you can't be heard to complain that the fees started to rise because you litigated appropriately, zealously, and you required the other side to litigate the case.
The other side raised disproportionality, or that was a sua sponte observation by the judge?
I think that was sua sponte by the judge, Your Honor. In terms of the hours that were actually worked on by counsel, the judge never made any determination that they were reasonable, never made any determination, or not reasonable, never made any determination about what was the value, the market rate of counsel. And that's the second issue I wanted to raise, Your Honor, the lodestar issue. Under Stratos and Fontaine, it's black letter law that the trial judge is supposed to be using the lodestar method unless there are special circumstances to depart from that. I cited the Hyannis Angler case. That's a case where the court said the trial judge should have used the lodestar. So the fact that the lodestar wasn't used and there was no determination here means that that also was an abuse of discretion, as was not dealing with all of the interests. I should also just note that it's not true that the SJC or the appeals court has said if there's a low dollar value, we're automatically going to say you don't get your attorney's fees. Twin Fires is an example of a $100,000 damage award, $1 million attorney's fee. The Sutton case was $1 and $165,000 attorney's fee. Those were all, in reviewing what the purposes of the statute were, the court affirmed those. Unless you have some other questions on the attorney's fee, I'm going to move to the underlying claims. Your Honor, the other side appealed the 93A and the 186.14 claims. I want to say there was no argument on the 186.14 claim, and so our position is that that was waived. It's mentioned on one page, the words, Chapter 186.14, but no argument, no citations under Rule 16. We believe that that argument is waived. And unless Your Honors have any discussion about that, I'm going to move on to the 93A. As to the 93A claim, the court found as a matter of fact that there was a rental agreement between the parties at $217 a month. It's black letter law that payments that are made in advance and accepted without reservation create a tenancy, citing to the Staples and the Stracharski case.
When would you, if you had to pick a month, when would you say the tenancy and sufferance changed with tenancy at will from your?
The court found, Your Honor, that it was October 2020. And that there were a number of payments made October, November, December of 2020. I also want to add that there are two exhibits that were in evidence at the trial. One is the 2022 notice to quit, and the other is the ledger that seems to show that $1,000 were owed every month. There are no other documents in evidence, and the reason I mention that is the other side in the reply brief says, oh, you need to look at other documents, you need to look at these other things that say perhaps he did try to reserve his rights. Those are not in evidence, not before the court, and I just want to make sure that that's clear.
Where is the ledger? Do you know where in the record appendix? I couldn't find it.
Oh, Your Honor, it's one of the two exhibits. I think it's after the court's decision. After the transcript of the judge's decision, there's a notice to quit, and then there's a ledger.
Can I ask a question?
Yes, Your Honor.
Is the very first time that the landlord tells the Guzes, I've been expecting $1,000 a month, is the first time he says that 19 months after he says he was first expecting it?
Your Honor, he never says that. Instead, he hands them this notice to quit.
But that notice to quit is
I'm
the
sorry.
first place in which he suggests what your rent has been is $1,000 a month and you have underpaid it.
Yes.
And it's for 18 months or 19 months.
That's undisputed, Your Honor. That's correct. In any case, so the 93A claim is that the landlord asked for this money that was never agreed to. I should say that was a decision in the first appeals. We cited that the court specifically found, the appeals court, it's a Rule 23 decision, said that asking for money that's clearly not owed is a 93A violation. That's exactly what happened here. And the court also found that it was willful and knowing. And the other side, rather than arguing that it's clearly erroneous, because that would be the standard since the court found these facts, simply says you should use this other number. You should ignore what the court did, ignore the rental agreement, simply just use $1,000.
So I'm looking also at this ledger, which has dates of receipts and check numbers and so on. Do we know when this was created?
The ledger?
Yes.
I believe the testimony of the principal of the landlord was that it was created prior to doing the notice to quit, that there was instruction to the bookkeeper to do this.
Immediately before.
I think I don't know exactly the date, Your Honor, but
But it
sometime
is clear
before.
that it was not, that none of it is contemporaneous.
Oh, that's correct. Yes, Your Honor.
The second notice to quit.
Yes, the 2022, the one that's in evidence in this case. Your Honor, I see I have 2 minutes left, and if I can, I just would like to wrap, unless Your Honor have questions about this. I just want to say that you're aware of the statistics, the access to justice issue here of tenants in eviction where fundamental right is at stake, that is their housing. 7% of tenants in the Commonwealth have an attorney. 90% of landlords have an attorney. And this kind of decision will only discourage attorneys from doing these kind of cases, especially for the poor tenants who need it most. And so if it's going to be that if your case is worth $1,000, you get 5 hours, if your case is worth $30,000, you get 40 hours, that's going to only exacerbate the incredible access to justice issues that we have in the Commonwealth. Thank you very much.
Thank you. We will hear next from Attorney Farber.
Good, I guess now it's afternoon, Your Honors. Lawrence Farber for Hyestan Industries. I'm not sure which one I should deal with first, but let me deal with the underlying, because it seems there is a concern here as to why we feel that there shouldn't have been any award of attorney's fees whatsoever, and why there was never a finding that there was a tenancy. You had asked earlier, when was the second notice to quit served? It was served very shortly after the judge had made a decision that on the case and saying that there was that the use and occupancy was $1,000 a month. So based on the $1,000 a month decision, which we feel is an issue of preclusion against it, they dated back to, okay, they've been occupying this thing since the beginning of when we purchased the property.
So you sent
What?
So you sent a backdated ledger?
We calculated what they should have been paying for use and occupancy.
You sent something that indicated an amount, and then when there were checks, what the check was, month by month by month by month.
I think you're getting it backwards, Your Honor, if I can. when the decision was that the use and occupancy of the premises was $1,000 a month, and that should have started from the time that they held over from when my client purchased the property. They then said, okay, it was $1,000 a month for all this period of time. They've paid so much, we deducted that. We deducted out, my client deducted out the amount of the judgment from GUZ 1 even, and said, all right, that leaves 12,000 something.
So what month did you get this decision, the one that said $1,000 a month use and occupancy?
It literally was the next month that they served, the next month they could.
So it was 18 months after.
That is correct.
Okay, and let me ask you this. I mean, that's fine and good. What about the rule that you had created a tenancy at will by accepting the payment?
I was going to get to that, Your Honor, if I may.
Yeah, sure.
Okay. If you take a look at the case law and the statutes, you will see that in this specific instance, it's not just he pays money and therefore that creates a tenancy. There are a number of factors that distinguish this from all the cases that he's relying on that says that gets created. First, a notice to quit in GUZ 1 was served, and this is part of the admissions on page 42 of the documents that you have from the trial, that 9 days after my client bought the property, he served a notice to quit now it was for no fault at that time, but it had a reservation of rights in it.
Yeah, but that case was dismissed.
What?
That case was dismissed. Presumably, the notice to quit.
At that point, when it was dismissed, the problem, Your Honor, is at that point, until a determination was made as what the use and occupancy on the property was, they had no grounds to proceed. We were told
the first notice to quit served when your client, like 9 days after
he purchased the property.
The first notice to quit had a reservation of rights saying any money accepted hereafter.
Yes.
Where is that in the record?
It was in the record in the first GUZ case. We didn't realize, the trial attorney didn't realize that it should be submitted in the second case, but because we didn't realize that that was going to be an issue here.
Was this argued to the judge? I mean, in the second case, that no tenancy could have been created because of this reservation of rights?
I can't remember whether that's in the transcript.
Certainly didn't see that discussed in his decision.
Yes, I can't
I
say, but there was a notice to quit showing an indication, and there is a reservation. I have the notice to quit, but I don't know if it's not part of this record.
You think that if you have a notice to quit attached with an attached reservation of rights and the case is dismissed, that reservation of rights lives forever?
Soon after that case was, at that point, my client couldn't do anything, because we couldn't do a notice to quit for no fault. The court had just told us until this court overturned him that was precluded from.
Well, you didn't have to agree to a rent. You could have said you owe me use and occupancy. Your tenant's at sufferance. The number I'm coming up with is 800. The number I'm coming up with is 600. I think it's about 700.
But
you didn't do that.
What this court is now saying to my client is you have to offer someone a rent and offer them a tenancy.
Not a rent, use and occupancy. Or maybe you go into court and say, well, they're still there, and I haven't agreed to
And that's what we tried to do initially by saying that they're there, but we were told
you tried to kick them out.
erroneously that we couldn't.
You tried to kick them out. I'm saying after that's dismissed, they're still in your property.
That is
okay.
Correct.
How are they supposed to know what to pay you?
At that point, the case was still pending as to...
On appeal, but there's a final...
there was also still pending at that time until the judge made the determination as to how much of the use and occupancy was. My client
Wait, it was pending for 19 months?
That's correct.
Without an appeal?
That is correct. The final decision, even after that part was done, did not come until 2023.
After the appeal? The final decision is after we reversed.
The appeal came down in 2024, late 2024.
Okay.
So part of this was extended because of timing, because of COVID, other things like that had delayed this tremendously. And my client had no other option of how to proceed until we knew what the amount was going to be that they were able to request, and we had a final judgment. So, because
I'm guessing you were in no rush to find out what you owed them,
well,
right?
I want to stress I was not trial counsel.
Okay.
All right. So when you say that, I can't answer that question directly. But Your Honors, the other reasons why this doesn't is not only did they always show they wanted the property back, period, between the first notice to quit and then a second notice to quit in this specific instance, but there is two cases, there's three cases that kind of support this position. The biggest being, of course, the Davis v. Comerford case, which addresses use and occupancy directly and says, you owe it, period. Doesn't matter what you, even what you
But it doesn't
are.
allow the landlord to set it unilaterally. The landlord needs to get the court to set it, and it can do that on a preliminary basis while the, after you've commenced the summary process action.
Right, but we were waiting for that to see whether that was going to be rendered. We didn't have a decision at all at that point outside of a dismissal on my client's part.
But correct me if I'm wrong, could not the second eviction have been commenced? Oh, I guess I was going to ask if that could have been commenced as a no fault, but at that point,
that was precluded from us.
The ruling was still in place.
That was the only part of the case that had been decided at that time, is you can't proceed on a no fault. The second cases in this is the Rubin v. Prescott case, which says that you have to consider that payments do not automatically, if an occupant pays money, does not automatically, by acceptance, create a tenancy. You have to look at it instead. In that case, they didn't find it, and we think that is also here, because what happened in this case is the tenancy itself changed, the occupancy, I should say, changed. There was a tenancy, but it was a land. It was for a plot of land in a mobile home park. When they lost the mobile home park, that now became an impossibility for them to have a rental for a plot of land because they didn't own
Well, here's what the judge said about the reservation of rights and the formation of a tenancy. This is in the judge's trial decision. Record Appendix 233, Note 2. Hyastan's first notice to quit in December 2020 included a statement that monies paid for the notice, after the notice, would not establish a new tenancy. But Hyestan accepted several payments prior to serving the first notice to quit. And those payments were $214 or $217 a month. So what is the error in that?
The error in that was, it was not part of the notice to quit. It was on the summary process, so he incorrectly uses the word notice to quit because he also gives the date of December 20th, and that is the date of the filing of the summary process of 2020, not the notice to quit. The notice to quit was served in March 13th of 2020, but then the moratorium hit. And
but you don't know if it was raised before the judge below as a basis for not finding a tenancy. I mean, the only one he addresses is that first notice to quit, and the second one, of course, is subsequent to that.
Right. And he incorrectly states what the notice to quit said at that time. Because there was a reservation in that case. He's referring to the summary process case itself, at which for the first time they demand money, and it's the money that was still owed from the prior tenancy when they owned the mobile home but hadn't paid all the $214. It's a lot more complicated. I don't want to use up too much of my time on that, but that was also, there was overall litigation that was going on between the two parties over what the lot rents should be, and that's the reason why it was a little off on how much they owed and didn't owe, because that got changed through that litigation. But that part got thrown out because they said, look, you didn't mention any of that in the notice to quit, and there was nothing to agree that that's the, there was no statement as to ongoing rent, that was only for back rent. before when they didn't own when they still owned the unit itself. Your Honor, the other
Do
case...
you mention this reservation of rights in your brief? Because I don't see it.
I do mention it in, I think, the SIR brief,
In where?
in my reply brief.
In your reply brief. Okay.
Okay. The reservation of rights is the exact same one that existed in the reservation of rights for this case. It's kind of a standard reservation of rights that the trial attorney had used. The other case that is important in this, outside of the Commonwealth, which establishes that use and occupancy is always due, is the Staples v. Collins, which says that the court should look at all the factors to decide whether or not a new tenancy was formed or not just whether there was a payment made. And in this instance, our argument is there was a reservation of rights, there was 2 notices to quit that were done, there was no indication that my client ever wanted to form a tenancy with the Guzes whatsoever here, because they had already shown that they have an inability to pay, and that it had changed the fundamental, what was being asked to be rented anyway. You know, what they were occupying is now his unit. Let me switch real quick to because I don't have much time left, to the attorney's fees issue. If, despite all of that, and you don't buy my argument, and you say, nope, he's entitled to attorney's fees, the attorney's fees set by the judge were the correct amount. The important part that they seem to misinterpret here is the amount of time litigants litigated this case appears to this judge to be disproportionate to the interests at stake. Not to the amount of time, but the interests. This was a 45-minute trial. He gave them 10.5 hours for 45 minutes.
What are the interests at stake?
The interest at stake for the trial was
No, I'm not asking you that. I'm asking you, what were the interests at
That's what I'm
stake
saying.
that the attorney's fees went toward?
They were only for the monetary damages at that point. All the things that my colleague here has mentioned as important interests, such as possession, such as fighting a summary process, you do not get attorney's fees for whatsoever.
Let me ask you this. The statute provides for statutory damages of $25 and for attorney's fees.
That is correct.
I've seen a million cases, not a million, I've seen cases where you get statutory damages and whatever, $87,000 of attorney's fees. That's very normal. That's how it works.
I don't disagree that in some cases.
Isn't that wildly disproportionate?
It is, Your Honor, but the question is how much time should these interests have taken? It's not how much, he says the time.
Well, if
The
the
interest at
judge had
stake,
done,
disproportionate to the interest. The time litigated, disproportionate to the interest at stake. That's a very different thing than saying in a discrimination suit, we're trying to show that there was a discrimination here. The actual damages for the discrimination were not great, but it's an important right to have supported here. This, the right was, the landlord asked for, and we believe that we have
if you agree
that
if you were to agree, which I understand, of course you don't, that the underlying judgment was correct, then the interest at stake is making sure that landlords don't, 19 months after something happens, send someone a bill for $19,000 based on an amount of money that was never agreed to as rent, and you know, I mean, it's all that. Those are, I mean, it's not discrimination, but it's no good.
Well, but the point is, how much time does it take to litigate, and how much time should have it taken to litigate that issue relating to what your damages were for that, and whether it was a violation of 93A? That didn't take any time at all if you believe that the use and occupancy, which we relied upon the judge's determination as to use and occupancy for the basis of the second summary process, and therefore, was that really a 93A or a 186 violation whatsoever? And the one line I do say on 186, I just want to say was the same arguments for 93A deal with the 186.
Okay, your time has expired, but if I see further questions, I see none. Thank you both very much for your arguments.
Thank you.
The case is submitted. That brings us to the end of our sitting for today. I'd like to thank the court officer, and the members of the court staff for their excellent, as always, excellent assistance. And with that, we stand in recess.